il y aura l'heure de mon repas et il faut que je mange quelque chose.
D'accord, d'accord, comme tu veux, comme tu veux. Hello, it is a great pleasure to welcome you all. My name is Jorge Boucinhas, Secretary General of the International Society for Labor and Social Security Law and former Director of International Relations of the Brazilian Academy of Labor Law. It is with immense satisfaction that I welcome you to the international webinar, Brazil, United States, Difference and Similarities in the Formation of Labor Law in Anglo-Saxon, Common Law, and Roman-Germanic civil law countries. This webinar is a joint initiative of the International Society for Labor and Social Security Law and the Brazilian Academy of Labor Law. The International Society for Labor Law and Social Security Law was established in Brussels in June 1958. It is the result of the merger between the International Society for Social Law, São Paulo Congress 1954, Brussels Congress 1958, and the International Labor Law Congresses, Trieste 1951 and Geneva 1957. The International Society was founded with the following purposes: to study labor and social security law at both the national and international levels, to foster the exchange of ideas and information from a comparative perspective, and to encourage close collaboration among academics, legal professionals, and other specialists in the fields of labor and social security law. The Society's objectives are purely scientific in nature and remain entirely independent of any political, philosophical, or religious considerations. This webinar marks the beginning of an important initiative to foster dialogue between countries of the Anglo-Saxon, common law, and Roman-Germanic civil law traditions. It is only the first of many such efforts when envisioned for the coming years, aimed at stimulating comparative legal studies across these major legal traditions. To formally commence today's event, I have the great honor and profound joy of introducing Professor Jean-Michel Servais, the current president of the International Society for Labor and Social Security Law, and a distinguished figure in the field, particularly known for his exceptional career at the International Labor Organization. Jean-Michel Servais holds a doctorate in law from the University of Liège and has been awarded an honorary doctorate, Doctor Honoris Causa, by Attila József University, Szeged, Hungary. He also holds a degree in philosophy and humanities. He began his academic journey as a student assistant and later as an assistant at the Faculty of Law, University of Liège. During this time, he also practiced law at the Liège Bar. Professor Servais joined the International Labor Organization in Geneva in 1972, having been recruited through a competitive process. Over the years, he held various key positions, including in the Department of International Labor Standards and the Department of Working Conditions, eventually serving in the Office of the Director General. He also served as Deputy Regional Director at the ILO's Asia and Pacific Office at Bangkok, Thailand, Director of Operations for the Arab States at Beirut, Lebanon, Research Coordinator at the ILO, International Institute for Social Studies, and Special Advisor to the Director General prior to his departure from the ILO in 2005. He is fluent in French, English, and Spanish, with reading proficiency in Italian, Dutch, Catalan, and Portuguese. A visiting professor at the law faculties of the University of Liège and the University of Girona. He is an associate member of the Center for Comparative Labor Law and Social Security, Montesquieu Bordeaux 4 Université, and a founding member of the Swiss section of the International Society for Labor and Social Security Law. He also participates in several academic associations and serves on the scientific boards of various journals. He has lectured extensively in universities and institutions, particularly across Europe and Latin America. Professor Servais also took part in the project Vers un jus commune universalisable at the Collège de France. He is the author of numerous publications on international, European, and comparative labor law, which has been translated into several languages, including English, Spanish, French, German, Bulgarian, Portuguese, Japanese, Russian, and Greek. He served as Secretary General of the International Society for Labor and Social Security Law from 1988 to 2001 and was elected President of the Society for the term 2024-2027. Professor Jean-Michel Servais, thank you very much for your time.
Thank you, Professor Boucinhas, many thanks for this nice presentation. I would like to thank, first of all, yourself and the Brazilian Academy of Labor Law for the organization of this seminar, and all the participants from Brazil and from the United States for this opportunity to discuss comparative labor law and the important issue of comparing two very different systems. And indeed, I have focused my presidency of the International Society for Labor Law and Social Security on the studies on comparative labor law. The present day's globalization has many facets, we know. It comprises not only the transfer of capital goods and services, but also social, artistic, and even individual exchanges. It prompted to re-examine the perennial question inter alia in comparative labor law of the role of the global consideration and of national or local dimension in how social relations are arranged. It seems obvious that heightened internationalization of human activities has a lasting and profound impact on legal culture in every region or country. This being said, each culture defining characteristics continue to play a significant role on how people behave and work. And I take the term culture in a very broad, the German sense, including history, the respective role of the three social partners, government, employers, and workers, and the economic environment. And indeed, countries vary in relation to the respect of the law, attitude vis-à-vis work, and industrial relation system. We all know the extent to which positive law provides different solutions to common problems. They are different indeed in content, naturally, but also in wording, and I will insist on the danger of the translation. And last but not least, in the means of implementation, more or less imperative, more or less stringent. I should refer to the difference between United States on one side and Japan on the other. So the scholars in labor law should therefore analyze not only the parallelism of rules, set of rules, institutions, but the profound mechanism of those laws, namely the assumed functions and the determining factors in the creation and development of rules and institutions. Nothing is more difficult indeed for a written law scholar than to understand a common law system, and vice versa. I will just give you two examples. The first is a reference to the difficulties of the United Kingdom to integrate most of the provision of the European legislation because it was basically influenced by written laws. And my second example is a very old case of arbitration between United States and Guatemala about the application of the social clause of a trade agreement between the two countries. And the question was a question of liability. And therefore, you could see the difference of visions, or what is liability in one system and we don't. And there was clearly difficulties to understand each other. I tried to have the reference to this example, but I investigate too late and I was unable to do it. I am especially happy for that reason of the organization of such a seminar between two completely different systems of law and industrial relation, with your participation, experts with a long exposure on international comparison. I will not myself focus on American common law or on Brazilian civil law because you know them much better than myself. And I will basically draw some lesson from my experience in the International Labour Organization. And I will do it in two parts. In the first, I will take the example of the labor management relations, especially in continental Europe, and to speak about the so-called European social model, if any, and of the relationship between the trade unions, the political parties, and the state structure in those countries and in others. And in the second part, I will draw some theoretical framework from that to show that there are indeed various visions of law and industrial relations, and that the comparison should also take into account the implementation practices. The first part is the specific characteristic of a European industrial relations system. If you go back to history, you can identify at least three types of social policies. The first has been called enlightened despotism, where you have or you had an authoritarian regime with mainly technocrats on power, and they decide on social policies, but without consulting the people. It was the case in the past in Prussia or in the Austrian Empire. It was also the case in the past in Japan, South Korea, or Taiwan. No more now, and you know that the three pillars of the present system in Japan, with the lifetime employment, wage, social benefits based on seniority, and enterprise level trade unions. But before that, you had a system very centralized and very authoritarian. It's still the case to a certain extent in Malaysia and in Singapore. The second type of policy is what is called the laissez-faire strategy. You let the invisible hand of the market to arrange the industrial relation. There is little intervention from the states. The USA is close to that type, but not completely along that line, as we all know. It's a voluntary system with the emphasis on civil liberties more than on social rights. It means that in this approach, the state try to guarantee an equality of treatment and opportunity to everyone, but then the people are responsible for their own career and life. And that explains how finally the protection of the workers is coming, partially at least, through the human civil rights approach. The workers' rights are considered as part of the human civil rights. And of course, but that's, I would say, a discussion of the past, the socialist doctrine or the communist doctrine of the struggle of classes for the control of the states never caught on in the United States. There is their clear preference for enterprise or workshop level collective bargaining and an emphasis on local economic agents. And the third system is the so-called social economy system. It's indeed basically the vision, the approach of continental Europe, where the states is more interventionist, establishing more rules, because they wish to go beyond the civil liberties with a recognition of a duty of solidarity against the marginalization, the exclusion of some. I would say that in my view, it's more a common inheritance from the history in continental Europe than a piece of law or an approach of the European Union legislation, which has still a subsidiary role in social law. This European system refers to three historical realities. The first, centralized consultation and action in concert between the states, the government, the employers' organization, and the workers' organization, with, at the end, some formal social pact signed by the three partners or not, and with success in the consultation or not. But always you have this consultation. Social pact in the north, in Spain, Portugal, it's in Belgium, but less in France or in Germany. Nevertheless, look at the present ongoing discussion on the pension reform in France. There are consultation. Second, an elaborate system of social security and public services. I repeat, the voters, the European voters, refuse to accept the exclusion of some people. They consider that it's their duty to do it. And the government from the right as from the left try to do that with different means, but the objective is the same. And third, historically, is the Keynesian policy of intervention, not only in social matters, but in economic and trade matters. We will see that globalization has created specific difficulties to keep doing this. Of course, this analysis should not mask clear differences. And you have countries which are a little bit in between, like UK or Canada. And you have also submodels. I have no time to develop this here, but if you take 4 parameters the dismissal facilities, the employment benefits, the taxes, and the active labor market policy, you will see there are the differences between the Scandinavian, let us say the Nordic countries, the Mediterranean countries, the West countries, and the Eastern European countries. Well, second, the relationship between the trade unions, the political parties, and the state structure. The trade union, we know, has a political weight. In the totalitarian regimes, like in the communist country in the past and still today, you have close links between the ruling party, the government, and the trade union, and you do not know exactly who is doing what. But what is clear is that there is a transmission belt, as the communists were saying, from the top down, imposing what is called as superior interest. And that means also that strikes and other activities seen as detrimental to the regime are prohibited. And negotiation and collective agreements are under strict state control. I repeat, is the example, the typical example is the communist countries, including still Cuba, for example, today. But also you have it in one way or another in authoritarian regimes in developing countries. And of course, especially in the past, in the fascist countries. The role of the trade union in continental democratic Europe is different. Indeed, historically, they had very close links with the political parties of the left, with women or youth movement, with cooperatives and other social movement. And even if now the links are loosened, they keep an involvement in a number of institutions. They are involved in economic and social policies. How? They are part of the social security institutions, the management of the social security institutions. And they are part also of institutionalized joint bargaining committees for social issues and other issues. Well, the trade unions have faced difficulties with the new environment, with the globalization. Of course, the internationalization of the market economy have put at risk national Keynesian policies. Most governments, if not all, are unable to impose their own economic policies. Even Mr. Trump is going back today because the market is, the international market is too strong. In addition, you have obstacles to the coordination of the trade union actions. You have variety of domestic law. Look at the recognition of the trade unions. In the United States, the trade unions are fighting for their recognition by the employer. In most European countries, you have, or in many, you have criteria in the legislation for representative trade unions. And with filling these conditions, these criteria, they are considered as representative and the employer has to discuss or with them rather than with others. If you take the strike, in a number of common law countries, strike is a liberty. It means that you go not to jail because you are a striker, but the employer is also free to dismiss you because you are a striker. In the Nordic countries, strike is a collective right. That means that only the trade unions could launch a strike. And in France, it's an individual constitutional right. Of course, the effects on the people on strike is different. Take the collective labor agreements in UK. It's a commitment on the honor, the old gentleman agreement. In other countries, it's a private contract under private law. But in many European countries, there are procedures of extension of the effects of the collective agreement, at least to the whole enterprise, and many times to the whole sector of activities, the branch of activity. If we go further on, you have also a variety of visions of the trade unionism. In US, there are trade unions. It means that they are focusing on the immediate interest of their member. And to speak about syndicate means something revolutionary and rejected, basically. While in continental Europe, the trade unions still claim to defend the people at work, the workers as a whole. A last and more practical obstacle to the coordination is the clear reluctance of some trade union leaders to give up their power to international trade union structure. This being said, we have nevertheless many examples of action in common, lobbies, campaigns, framework agreements. And here also, I know best, of course, the European Union experience with the involvement of the trade union and the employers association in the elaboration of the European legislation, in framework agreements, and also in enterprise agreements. Second part, lesson to be drawn from this. There are indeed various visions of labor law and industrial relation depending on legal and non-legal elements, and not only in the comparison of the text, but in the implementation practice. And indeed, implementation practices should be part of the comparisons. How to implement and apply the rules. And I will give a specific example, is that should we take into account the social economic context to assess the application of the law? The various visions of labor law and industrial relation. The cultural dimension matters indeed. There is an impact of the culture on work, on the concept of work. If I go back to history and the ancient Greeks, the work, it was something extremely vulgar. for the low-class people and for the slaves, not for the upper-class citizens. If we jump for almost 20th century, we could quote a German famous sociologist called Max Weber and his book explaining the ways of capitalism by the Puritan Protestantism. His theory was that in the United States especially, this Puritan Protestantism was a strong movement, religion. And it means that the people were considering that their success during their life is a sign that they are elected by God. So they work hard, they earn money, but they are Puritans, so they will not enjoy their money and they will reinvest it. It could be a little bit simple, but that was clearly the explanation of one of the most famous German sociologists. And if I move to Brazil, to another sociologist called Sergio Buarque de Holanda, in his book Raíces do Brasil, he tried to understand why Brazil and United States, with the same people coming from Europe, the same immigrants, have so different level of poverty and development. And his theory was that indeed the Brazilian earn money, but then once they have the money, they wish to enjoy, and then they spend the money. And they do not keep the money for investment, etc. Again, you will say true, untrue. I will not enter into that, but it's revealing of a different concept. Impact of the culture on law. We all know that the respect for the law and for the authority varies a lot from one country to the other. We take example in Europe, in Germany, and in the Nordic country, you respect the law, the authority, for example, the tax legislation. In the Mediterranean countries of Europe, to elude taxes is a sport, and the people are proud of it. It's totally different, and I can multiply the example. Readiness to go to the court. In Brazil, like in the United States, the people are ready to go quickly to the court if there is a conflict. Compare with Japan, where to go to the court is the very last resort, to try to conciliate for a long time before deciding to lodge a complaint. Impact of the religion of the law. Indeed, I was in charge of the Arab region for the ILO during a certain time, and to combat child labor, for example, I asked my colleague to quote the Quran, the principle of the Quran, and it worked. But religion sometimes is also superstition. And again, a personal example, when I was based in Bangkok as deputy director there, I was invited to visit a cutlery fabric, and the manager had provided all the security measures, mask, helmet, etc. And then he explained to me that when he started his activities, he asked a monk to come and to bless the workshops. And immediately after, the Thai workers were putting out the helmet and their mask, considering that there is no need for it because they were protected by Buddha. So we have lying law to take into consideration all these elements, not to accept them, but to take them into consideration. And third, the impacts on industrial relation, the recognition of the trade union in USA has a cost. We all know that because most of the protection of the working condition and of the right on social security are still in the collective agreement. So to recognize or not to recognize a trade union and to enter into negotiation with them is a serious decision for the manager. And in addition, the trade union insists to have clauses in the collective agreement enabling them to oversee the post or the performances. So I would say, I do not, how to say, put a judgment of value on that, but it's clear that the system will be more conflictual and there will be more anti-union practices. You may say that in continental Europe, the industrial relations are a kind of straitjacket for the employers. Maybe. But it's true that everything is decided above the enterprise. You have labor codes, labor legislation, social security codes. The agreements may still are mainly signed above the enterprise at the branch level. And you have, I repeat, a social dialogue above the enterprise also. And the enterprise has to follow. So the question of to have or not to have a trade union in the enterprise is a question of feeling. Some are more irritated than others. Some consider that it's convenient to canalize the complaints of the workers. Others say, no, they are too aggressive. But it's not as essential as in the US. Impact of the culture at the international low level also. And I will just refer to the definition of cultural rights in the preparatory documents of the Declaration of Civil Rights and on the Covenant on Civil and Political Rights. It was interesting, and the second Covenant on Cultural, Economic, and cultural rights. It was interesting to see that you have a vision from the Western country focusing on individual rights and under the vision on collective rights, not only defended by the communist countries, but also by a country like India, for example, insisting on the protection of the minorities. And you have also a current now, especially not only in Africa, called human rights relativism. It means that they consider that the traditional civil rights are an invention of the Western country and do not fit with the African culture. I was invited once to a panel, a PhD panel in South Africa, in Cape Town, on a project of thesis on the abolition of child labor. And the incumbent was defending the idea that the abolition of child labor is not in the culture of Southern Africa, because it was always the case. Well, I was the only one in the panel to say, no, it's not true. It's a universal value, quoting only African authors, academics, to defend my position. But I was in the minority. It's convenient, I agree, that this relativism is a way to an easy justification of a number of, I would say, not really good policies. The pitfalls of a purely word-to-word comparison. Rather than comparing just two legal texts, we have to identify common problem, as I said before. Examine the various techniques to come to similar or distinct solutions and the reason for the choice. And to avoid, of course, to examine everything through the prism of its own legal order. The object of the comparison may be the systems. What is the power of the judge? Very different in common law and in written law system, like the law of evidence. It's interesting to examine the country which has been influenced by both systems, like some countries in Asia, Singapore, Malaysia, including Japan, Israel. And there was an interesting article in one of the last issues of the, how is it the title? The Comparative Labor Law and Policy Journal by Israeli scholar explaining how they have benefit from both traditions. Comparison of the institution, a group of rules, and we have to examine the function, the reason for the creation of such a system. And finally, the provision themselves. And here we have to be very cautious with the translation. A tribunal in English is not a tribunal in Spanish or in French, etc., etc. Civil service is something very different in Britain and in the translation in Spanish or in French. Many difficulties indeed, but also some instrument to help, like the glossaries. I have several glossaries in my library, and I even participate in the elaboration of one between the European Union countries. I had to give up after a time because I was moving out of Europe to Bangkok, and one of my colleagues succeeded. But you have also the ILO conventions and recommendations. Their official languages are French and English, and you have a rather official translation into Spanish as well. And you can compare. Not to say that there is no problems. Once in a while, we can observe, like in Convention 98 of the ILO on the right to organize and to bargain collectively, that there are sometimes differences, real differences. And then the question is, could we transfer the rules of a country to another one, and how integrate it could be? It's a natural attitude to look at other legislation when you wish to reform your own legislation. It's even more, it's almost automatic between the European Union countries. But the question is, who is comparing? Well, the legislators. That means civil servants, government, ministers, political parties and parliament, but also employers and workers, organization. And they compare with some objective in mind. It means that they use the foreign legislation to try to obtain something in the discussion of a law. On the discussion on the age of access to pension in France, the Nordic countries were quoted by the people which wish to raise the pension age, and other legislation mentioned by the left, which was refusing it. So you have many times a third element in the comparison, a value, an element that you wish to enter into the comparison. It could be a political element. It could be also a more neutral element or value like the ILO Convention and the value they try to integrate within the national legislation. Transfers exist since a long time. The colonial powers were always imposing their legislation in other countries. Today, you have also the big investors and the trades, the trade partners, which, when they are powerful, which also influences the legislation. And well, US or Japan in Asia, for example. You have also a major controversy about the so-called policy transfers and the influence of lenders like the World Bank, not only on the policy, but on the legislation, of course. And then the question is, to what extent can we easily import a system? I could quote Montesquieu, the French thinker of the 18th century. He was saying in his Spirit of the Laws that the laws are so different in terms of religion, climate, topography, demography, habits, that is really a great coincidence if the law of a country could fit in another country. But we have examples, but we have example of reject thing also. I remember a very old case in the 70s or 70s, I think. There was a prime minister in UK called Mr. Heath, and he tried to integrate the industrial relations system of the United States in Britain, considering that it's better. But he never succeeded. So the second question is, to what extent should we adapt the system? And then there is a fascinating book, an example, is the example of Japan and the USA. Japan imported after the Second World War the industrial relations system of the United States within Japan. But there is a major difference in the implementation. And I may refer to the PhD thesis or book, I do not remember exactly, of one of the old president of the National Industrial Relations Board of the United States, William Gold. And he was explaining in a book published by MIT in the years 80s how the Japanese culture reshaped the industrial relation and moved it from a rather conflictual system to a very quiet system. Implementation practice also matters. How to apply and implement, and of course, the interpretation of the laws varies. You have, depending on the system, more or less discretion, freedom of the judge, compare the freedom of a common law judge and the civil law judge, but also the flexibility in the control of the law. And in this case, I may refer, for example, to the Latin America, when the control is in many cases less strict than in other countries. But the example I would like to take in the last part of my presentation is the question, should we take into account the socio-economic context to assess the law? And I have a famous case in the history on the ILO, and it refers to the communist country USSR and the others. Those countries had in their constitution and legislation the recognition of the major civil liberties, indeed. But it was a recognition with an exception for whatever could be detrimental to the communist society. And who assessed the detrimental effects? It was basically the administration, and the administration was not really controlled by the judges, and the judges were not independent enough to correct the administration. They had a so-called theological approach. There was an objective, and everything which is not in full conformity with the objective should be rejected. The argument was rejected by the majority of the ILO committee, expert in the committee of experts for the application of convention and recommendation, saying, well, the law is the law. It could be hard, but you can only accept exceptions which are in the law, nothing beyond that. You could not interpret against the text, except, of course, if there are specific exceptions in the text itself. And the same, if I mentioned this example, because the same approach is used today, or adopted today, by a number of totalitarian regimes, especially in Africa. So I think my time is almost over. And I will just conclude saying non-legal element matters indeed in comparative labor law, especially the cultural one in the broad sense of the concept. And indeed, word-to-word translation is extremely risky. We have to compare the actual provision in their functions and in their implementation. Many thanks.
Thank you very much, Professor Jean-Michel Servais, for an excellent lecture. I can see here in our private room many of the future exposers, the future speakers here. So since we have something about 5 minutes, I want to share with all of you the opportunity if you want to ask anything to Professor Jean-Michel Servais. And at the same time, I'm welcoming Professor Jeff Vogt, Professor Gus Cochrane, Professor Sergio Torres, and Professor Liz. I think Professor Liz has a question. Please, Professor, the word is yours.
Hi, thank you so much. That was so interesting. I thought the cultural dimension of law was so important, and I was hoping you could elaborate more on what you were talking about in Japan and the transformation of the industrial relations system to a more peaceful system when it was adapted to the Japanese culture. Could you talk about that a little more? And I think you quoted a scholar, but I didn't quite catch who it was. So if you could just elaborate more, I would really appreciate that.
For sure. The book, I do not remember just now the exact title, but the author is William Gould, Gould, and it's reshaping something like reshaping the American industrial relations system in Japan. And it was published in the MIT Press in, I would say, 84. The Japanese society, and I work there a lot, hates conflicts. They do everything to avoid a conflict. I was there once facing a strike, and the strikers were going and working, but they had a sign on their front saying, "We are striker, we are not happy." So it's something very specific. And it's only the last resort to do it. When they do it, then it could be very violent, but it's the last resort. So imagine the system of recognition of trade unions by struggling in a country who hates the struggle. They do it by discussing and discussing. I was once attending a negotiation session between the municipal workers of Tokyo City and the authorities of the Tokyo municipalities. And it took, I had my translators, and it took hours and hours, and it was awfully boring. But at the end, they succeeded after hours and hours. This is Japan. They move also from the system based on enterprise discussion to something which is more common with the Europeans. You have every year in Japan the so-called Shunto, the spring offensive, when the trade union, it was around April, decided to put ahead their claims for improvement. We don't strike, but they come with that. And they do it through consultation at the national level of the trade unions. And to counteract this, the major enterprises have also their consultation amongst them at the Japanese level. And in Japan, the government is never very far because they consider that it's their duty to see if there are no wage drift, for example, or something. They have to take care of the economy, the good shape of the economy. So you have informal discussion at that level also to avoid strike, to avoid conflicts. And I could multiply examples of that kind, but you will find this book. It's fascinating for me.
Thank you so much.
Thank you, Professor Jean-Michel Servais. Thank you also, Professor Liz Tippett, for your intervention and for your question. We'll go to our first panel. that would be about collective bargaining as a tool for the construction of labor law in Brazil, in the United States. But due to a last-minute emergency, we'll have to split those presentations. We'll hear from Professor Gus Cochrane about the American experience, and then Professor Guilherme Feliciano would explain a different topic about trade unions in Brazil, our model in Brazil. And in the afternoon, in the first panel in the afternoon, I'll talk a little bit about the collective bargaining in Brazil, especially after the labor reform in 2017. So in this precise minute, I'll welcome Professor Augustus Cochrane, Emeritus Professor at the University of Atlanta, Georgia. He is also a very, very good friend of Brazil. He has been here many times lecturing in different universities in Rio, in São Paulo, and in some judicial institutions and schools. Professor Gus, can you hear us?
Yes. Hello. How are you?
Very fine. It's really, really nice to see you again.
Good to see you, Jorge. I'm going to try to share some slides.
I think you are already able, but if you have any difficulty, I have your slides here with me. I can help you.
When I hit share slides, I get a message it's not turned on. Send a request. Maybe it's up to you.
I'll make you co-host.
Okay.
So you can, I think you're now able to share your slides directly.
Yes. How's that?
Perfect. For me, I can.
Okay, now it's sharing, right? Let's see if it works. Yes. So thank you, Jorge. It's a real honor to have this invitation and to participate in this webinar. I'm going to try to talk about collective bargaining in the U.S. in a common law context. And it's a very broad topic, so I'll only be able to hit it in broad brushstrokes. But I wanted to begin by saying, unfortunately, I speak very slowly. I'm from Atlanta, Georgia, and Atlanta is famous for its trees. This is a picture of my college, Agnes Scott College, in the fall, but also for its accent. So I have a very thick Southern accent. People who hear me speak Portuguese without doubt think that my Portuguese is un pouco estranho, but my English is esquisito also. So I'll try to speak quickly, but I can leave my slideshow, make it available, or you can email me for that also. So obviously the United States is a common law country because we were a colony of England. We inherited that. In England, traditionally from the Middle Age, employment was regulated by a law called master-servant, for example, and it treated employment as a status with both parties having benefits and duties as well. For instance, leaving an employment before a year, typically, if the term wasn't specified, was something that employees were not able to do. They also had duties such as loyalty and obedience. They enjoyed certain protections and benefits as well. But in the United States, which inherited this kind of approach to employment law, in the 1880s, judges, influenced especially by Judge Horace Ward, began to change their view of employment as one of free contract. And if the contract didn't specify a term, a length of duration of the contract, the judges began to consider employment at will, which means that either party could end the contract at any moment for any reason. And this created more liberty and mobility for workers, but it certainly produced a less secure employment situation because, as one famous judge wrote in an opinion, the employer can discharge the employee for good reason, for bad reason, or for no reason whatsoever. Obviously, this produced harsh conditions for employees, lack of security. The famous German social theorist Karl Polanyi wrote that this is an example of the movement of liberalism in the 19th century to create a kind of market society, utopian society without any social regulation. But he thought it was doomed to fail. For one reason is that labor is not a commodity. It's human beings with needs and rights. And so he thought there would be what he called a double movement to protect workers. And that, I think, more or less describes what happened in the 20th century in the United States. Attempts to sort of modify this at-will employment in the New Deal in the 1930s during the middle of the Great Depression to create a Fair Labor Standards Act that imposed minimum wage and the concept of maximum hours or overtime, but also the National Labor Relations Act, which protected the right to organize, to form unions, and also to collectively bargain. Another wave of regulation came in the 60s with the Civil Rights Movement. The Civil Rights Act had Title VII that forbade employment discrimination. There was some movement in the end of the century to modify this common law at-will employment in various states. And also some national legislation to protect health and safety in the workplace, to protect retirement funds if they were offered, et cetera. This is my attempt to chart what the resulting system looks like. Obviously, there are limitations on employer power or employer discretion to set the terms of employment. On the right-hand side, by contract, either an individual contract if you are a very skilled or professional employee, or by collective bargaining if you belong to a union. I'm going to point out that very few American workers these days belong to unions, and very few have individual contracts that spell out many protections. On the left-hand side of the chart, you can see those three waves of law that override the at-will nature of employment, protecting the right to organize, forbidding employment discrimination based only on certain characteristics like race or religion or sex, and then various other kind of statutes. But I've tried to picture the bulk of the discretion or the bulk of the power remains with the employer, because the common law at-will doctrine is the default setting. If there is no law forbidding it, the employer is able to discharge an employee for good reason, but also for bad reasons, as long as they're not illegal reasons or no reasons whatsoever. So there are cases where people's political opinions got them fired, or wearing the wrong football team's jersey, obviously American football, not soccer, but football jersey, or even drinking Pepsi-Cola if you work for Coca-Cola can get you fired. So it's a system without much protection for the workers, except those contracts and laws. I have a couple of friends in Brazil that are very well-known writers on employment law, Cássio Casagrande and João Renda Leal Fernandes, that both talk about the American myth. Apparently, many people in Brazil are under the impression that there are no employment laws or worker rights in the US. That's not true, but I would say they are few and far between and somewhat weak. Again, part of this myth is that American workers live in a paradise, have great working conditions and high salaries. That's the part I think is really the myth, because I think American workers are living under pretty dire circumstances today. So let's talk about the National Labor Relations Act from the Depression, the New Deal, 1935, the main law that protects the right to get organized and collective bargaining. Labor law professor Carl Clare has said this is the most radical law ever passed by the U.S. Congress, and it's not hard to see why he thinks that. If you look at the purposes right in section 1 of the law, there are a lot of purposes that are really unusual and radical in American law. One is they were designed to protect actual liberty of contract as opposed to a formal right that was used by courts in several instances to make very anti-labor rulings. It is to restore the equality of bargaining power. In my opinion, this is one of the few instances where American law recognizes the inequality of bargaining power as opposed to the sort of formal equality of parties to a contract. I think hypo sufficiencia is a concept that's not strange to Brazilians, but it's not widely recognized in the United States. And at least this first version of the NLRA, the Wagner Act, was explicitly to encourage organization by workers and collective bargaining. There were also some aspects that you could call New Deal liberal. There was a sort of Keynesian or pre-Keynesian idea that by restoring wages and purchasing power, that the Great Depression, which was seen as caused by lack of demand, could be overcome. And there were also conservative nods in the purposes, the friendly adjustment of disputes instead of strikes to aid the free flow of commerce. I think this was largely put in to get the law approved by the Supreme Court that had been striking down other aspects of Roosevelt's New Deal until he packed the court. And in fact, this law was upheld in the Youngstown Steel decision in 1937. But these more conservative purposes have also been used by judges across the decades to give more conservative interpretations to what the National Labor Relations Act was intended to do. The coverage imposed some limits, usually in the definitions section. It exempted government working, so if public workers are governed by the state or federal laws different, and many Brazilians know the famous Janus case from 2018, where Supreme Court is imposing constitutional limits on workers' rights in state government jobs. A lot of employees were exempted by statute, either in the original bill, domestic and agricultural workers that had a especially strong impact on minority, especially Black workers in the South, necessary to get the votes to pass this law from conservative Southern representatives. Other laws have added to that, either from congressional amendments that excluded supervisors or Supreme Court decisions excluding managers. Independent contractors now is a very interesting one that I know Liz Tippett knows a lot about. I think we are in a kind of situation where whether gig workers, platform workers are included as employees or excluded as independent contractors is kind of all over the map, very unstable, I think, at this point. The main right that was guaranteed by this National Labor Relations Act was to self-organization, to join labor unions, but it also includes the phrase to engage in concerted activities. They have to be concerted. I always tell my students, don't go as an individual to your boss and complain about your job because you're an at-will employee. Typically, you can be fired, but if you take one other coworker, you can claim that you're engaged in protected concerted activities. Obviously, there's some limits. Besides this, they have to be legal activities. It can't involve violence. There's some interesting judge-imposed limits like loyalty, for instance, which is a sort of carryover from the old master servant. And then Taft-Hartley added the right to refrain from any of this activity. In terms of representation, this is very complicated, but there are elections to choose representatives of the choice of the workers. These are majority representatives. The law itself does not require an election, but the law has been amended now, and the practice is that the employer always objects, basically, and so the National Labor Relations Board will hold an election if the union can demonstrate substantial support. And representation is exclusive, sort of a version of unicidade, but it's, again, based on demonstrative majority. The law in Section 8A originally included unfair labor practices by employers that constitute interference with the exercise of these rights to self-organize and engage in collective bargaining. The other important right is against discrimination, etc. You can see that there are several rights, all related to getting organized and bargaining collectively. And it created a National Labor Relations Board that administers, adjudicates cases, interprets the law, enforces the law. Interestingly, I'm not sure I'll get to the end, but it's being challenged by Elon Musk's SpaceX and Bezos's Amazon and several other large corporations as essentially a violation of the unitary presidency or separation of powers. It's got a headquarters in Washington. It's been cut back severely in terms of budget and staff. It's supposed to have 5 members appointed by the president, confirmed by the Senate for staggered times to give a little independence from the president. It requires a quorum of 3, which is important because right now Trump is trying to fire one of the Democratic members, and there are only 3 right now. So if there are only 2 members, we essentially have no labor board and therefore no enforcement of labor law. And it's traditionally been partisan, but the swings of their rulings have become increasingly wide and crazy with the political polarization of the country. In 1947, a Republican Congress enacted over the veto of President Truman the Taft-Hartley amendments that made the labor law much more conservative. They added the right explicitly not to join as well as to participate in union or concerted activities. They added a section of unfair labor practices that unions could engage in to match the unfair labor practices that employers can do, especially outlawing secondary boycotts. When a union enlists other unions and or exerts its powers to strike or boycott against other employers to try to force those employers, say suppliers or customers, to force a company to accept unionization. It included what's called employer free speech, which gave the employer, which it previously had been required to be neutral in organizing elections, to oppose unions, and gave them very powerful tools such as captive audience meetings or making predictions about the economic consequences, even the closing of the company or the plant or office. It can't threaten, but the difference is, I would say, imperceptible to workers, or maybe to say it's perceptible only to lawyers. Allowed right to work, which these are state laws that now a majority of states have. At first, it was very few, mainly southern states, that allow people to benefit from unions that represent their group, their bargaining unit, without paying any union dues or even any cost agency fees to negotiate the benefits from which they benefit, creating a huge free rider problem. And defined more clearly that good faith bargaining doesn't require the employer to agree to a contract. And so nowadays, something like a half of the unions, after they're formed, don't succeed in winning a contract, a collective bargaining contract in the first year. Something like a third don't succeed even after 3 years. It's a powerful tool for employers to kill the new union and have a decertification election. Another amendment in 59 just guaranteed rights to union members in their unions and instituted reporting. I'm just going to do a really brief detour to talk about basically direito do trabalho individuo. I mean, to most Americans, employment law, as opposed to labor law, meaning the collective bargaining union law, employment law is basically individual rights, and that's basically, to most people's understanding, Title VII anti-discrimination law. It just forbade discrimination on certain bases. We've added a few like age and disability, but again, the default position is if it's not illegal, the employer can do it. So for some time, we don't have a law, national law, against sexual harassment, for example. And so it's not till 1986 that the Supreme Court says sexual harassment is discrimination based on sex. Some of the early decisions said, no, refusing to sleep with your boss is simply a bad practice. That kind of coercion is immoral and unjust, but it's not discrimination because of sex. It's because of your refusal to have sexual intercourse. Well, that kind of weird ruling was changed. Again, it's a great example of common law judges, in effect, legislating that sexual harassment is illegal. We had a similar analogous situation. Sexual orientation was, courts differed, but to a great extent not considered sex discrimination. It's sexual orientation discrimination. It took a 2020 Supreme Court decision. Very interesting because the conservatives split as to how to interpret the law, but now at least it's being opposed by a lot of conservatives these days, but right now it is considered sex discrimination. I might add, of interest to Brazilians, I think, is that we don't have a category in the United States called moral harassment. So if there's abusive behavior by an employer, you have to pigeonhole it, categorize it as some other illegal type of behavior. You can't just say moral behavior because, again, just abusive, arbitrary treatment of employees is protected for the employer by at-will employment. The EEOC administers this law. It's generally, I think, the employment lawyers I know see it as really weak and almost a barrier. Most of the enforcement comes when the EEOC issues a right to sue letter. And so the model of enforcement is more a private attorney general's private suits or litigation model. And I just wanted to mention that a study by some ABA researchers found that despite the sort of public image of huge lawsuits and huge settlements and awards for sexual harassment and discrimination, in fact, very few cases first place, very few victims ever complain. Very few go to court. Very few make it to trial. Once they are, there's a decent chance, like a third chance of winning. But if you look at the chain, it's really tip of the iceberg, as they say, that employers are held liable for sexual harassment. And I just wanted to, I've got a list here, what I think are the problems with using a litigation model to have private plaintiffs, victims, try to enforce the law. Mainly, it's very costly. We don't have a justicia de trabalho in the United States. You have to go to general courts, and it puts the burden on the victim. So I need to wrap up, and I guess I'm out of time, but I've got a series of slides if you want to look at. I want to say that it seems to me that there are, I'm missing some slides. I guess I want to, well, no, this is the right slide. The decline in union membership has been extremely drastic. We now have fewer workers organized than we did before the passage of the law, the National Labor Law, before the Great Depression. Something like 6%, I think it slipped even below 6% of private employees, 10% overall, because public employees are more unionized. There are tons of theories and explanations about the cause of this drastic decline, changing nature of the economy to a service economy, globalization, the capital flight, capital mobility. I would emphasize employer hostility. It's always been massive in the United States. And the tools and tactics employers use against worker organization is just overwhelming. Sometimes I think it's amazing that anybody ever has the nerve and the will and the determination to unionize in the United States these days. I think I've got a slide to emphasize some of the flaws in the law. Obviously, some of the amendments have drastically weakened the law. And as you can see, some of the administrative issues are very serious too. And the enforcement agency has been attacked and whittled down. But there are also a number of judicial things. Carl Clare talks about the judicial de-radicalization of the National Labor Relations Act. Judges have read in sort of common law doctrines of master-servant protecting property or requiring loyalty from employees. And so there are a number of people who think the labor law badly needs updating. It's approaching 100 years old. It's about over 65 years since it's been amended. There have been a number of attempts to reform. They basically have all failed. Political scientists Hacker and Pearson have this idea called drift, where the law itself doesn't change for the worse, but where social conditions make the law inappropriate to the new conditions that new problems it's supposed to solve. That last, I just recommend the most fullest set of recommendations for reform are coming out of Harvard Law School, Clean Slate for Worker Power. It's worth Googling and looking at that. Now, I think I can wrap up by just saying we have suffered great inequality in the neoliberal era in the United States. As you can see, income has not kept up with productivity. All that share of labor has been declining. Most of the gains have been going to capital. We have moved from a situation during the New Deal and after World War II that people have called the Great Convergence, where incomes inequality began to lessen. Now it's the Great Divergence, The wealthy have taken off. It's even worse. You can see we're back to the kind of income inequality we had during the Great Depression, very worrisome if you're worrying about economic conditions as well as about worker welfare. Wealth is even more unequal, and you can look at the slides longer. This is the one that really impresses me. The top 20% is getting something like 90% of the wealth of the country. The bottom 2/5, the bottom 40% are actually in the hole. I heard Bernie Sanders say the other day, 3 men, own more wealth in the United States than the bottom half of the population. I just wanted to close by saying unions are important. This decline in union representation is important because as unions have declined, wealth has increased. I think I've read that something like 1/3 of the growing inequality can be explained by a lack of unions. That's another map chart showing that. And finally, not just economic inequality, but political inequality. Unions are really important for democracy, for popular sovereignty. They've proved that they encourage engagement, voting participation. They fight anti-democratic measures like voter restrictions. They've been shown to combat prejudice and foster democratic attitudes. So that's my presentation. If you want my slides, email me, or maybe Jorge has them also. So I thank you very much for your attention and apologize for running over.
Thank you very much, Professor Gus. It was a very, very wonderful presentation. Thank you again. I invite now Guilherme Guimarães Feliciano, who is professor at the University of São Paulo, member of the Brazilian Academy of Labor Law, magistrate, and member of the National Justice Council of Brazil. Professor Guilherme, the word is yours.
Thank you very much. Do you can hear me clearly?
Yes,
Do you hear me?
we can hear you perfectly.
So, good afternoon, everyone. It's an honor to be in this webinar in which we discuss the legal experience in Brazil and the United States in labor matters. And thanking my friend and professor, Jorge Boucinhas, for this invitation. I will move on without delay to my exciting topic, that is the legal system, the union legal system in Brazil, with a projection. Wait a minute. Okay. So, yeah. It's necessary initiate to talk about the constitutional principles of collective law or union law in the Brazilian system. We have principles in our constitution, and one principle is the most important among all the constitutional principles about this. That's the principle of trade union freedom. Do you know we have the Convention 87 for International Labor Organization. That's a natural derivation of the fundamental rights of association and peaceful assembly. The right of association is a fundamental right, is a basic right in our constitution, in the famous Article 5. And this freedom of association or trade union freedom has two dimensions. One positive dimension, that is free creation and free linkage to an union, and a negative dimension with the text of our Article 8 in the Brazilian Constitution. I read, no one will be forced to join or remain a member of the union. But Brazil, the Brazilian state, is not a signatory of ILO Convention 87. And why not? That is because we have in our constitution reminiscence of the fascist model of union organization that the President Getúlio Vargas introduced in Brazil in the 30 years. And now, as this reminiscence in the Article 8 of our Constitution, we have a terrible condition that the unions are enshrined unit. That means that we can have only one union for each professional or economic category per territorial base. This is our principle of unit unions per territorial base. And we had to, a mandatory state financing of unions. That is an union tax to financing unions in Brazil. And a third element, that is the normative power of labor courts. This is a controversial institute in Brazil because some jurists thinking that this is a reminiscence of that Italian fascist corporatist model that we had in Brazil, and other jurists think that this is a legitimate element of judicial control of conflicts of an economic nature. So we have two opinions about this normative power. But this fact is our labor courts in Brazil can decide the new labor conditions for the future as a rule of law respect to workers in a category, in a professional category, per territorial base. This is possible in Brazil by judicial courts and not by parliament. So because that three elements, we don't be able to signatory the convention 85 or 87 because we don't have really union freedom in Brazil. It's not possible have 2 or 3 unions in the same professional category per territorial base. Is it not possible in Brazil? We have the principle of trade union autonomy. A famous jurist, a famous Brazilian jurist called Amaury Mascaro Nascimento, said that trade union autonomy means internal democracy plus external autarky. And we have this principle in the Article 8 of our Constitution. That means prohibition of intervention and interference by public authorities in the legal union system, in the legal union organization. Intervention means administrative control takeover, and interference means any external interference in union activity. And because this principle, we have uncontroversial effects in Brazil. No need for union registration for the purpose of legal constitution of unions. So, a union can be created without a public registration in the Minister of Labor, for example. Is it not necessary? Is it only necessary have a registration in a regular unit of registration of legal entities, only this, and not in the Ministry of Labor or in a Secretary of Labor, in a public organization to control units. It's not necessary. And that was a question in Brazil. Now, after our Constitution of 88, we can say affirmatively that unions are private entities, because in our consolidation of labor laws, it's the first and most important labor act in Brazil. We had an article saying that appropriation of union assets would be embezzlement. Embezzlement in Brazil is a crime against the state, and unions don't make part of the state. So this legal provision is not now effective, because I can repeat, unions are necessarily private entities in Brazil. About our form of union organization. In the global perspective, we have maybe 4 forms of worker organization or union organization. By major business segment, this is the German model. Unions for workers in service, in industrial, in financial, in agriculture, in commercial sectors. A second form, by company. I think this is the common form of union organization in the American system. So we have one union for each enterprise, or it's possible. In Brazil, is it not possible? Because we have a model of organization by category. And in our opinion, this organization by company reduce the possibility of generalizing negotiated achievements. We have a form of work organization by profession, by drivers. So a union for drivers, a union for nurses. In Brazil, this is the so-called differentiated professional categories. Differentiated professional categories. And the main model in Brazil, the most predominant model in Brazil, is the organization by category. It's the dominant form. And we have professional categories and economic categories. So it's our basic model of worker organization now. Thinking about this, we can imagine that the representativeness of social sectors in individual and collective labor relations varies worldwide. In the European continental model, for example, in several countries, we have the qualities of guaranteeing freedom of association and facilitating the spontaneous strengthening of unions. In Germany, we have only 20 main national unions now, and in Brazil, more than 9,000 unions. 20 unions in all Germany now, and more than 9,000 unions in Brazil now. This is talk about the difference between our model by category and the German model by major business segment. It's a best model, in my opinion, the German model. About the financiation of unions in Brazil. Traditionally, we had 4 hypotheses, 4 forms of contributions in the union financing system. The union contribution or tax union. We had in Brazil a tax, a public tax to financing union activities. This is also a reminiscence of the public character of unions in Brazil, and it has an fascist corporatist inspiration. And I said, this is a logical impediment to Brazil for the ratification of ILO Convention 87. We have too the Confederate contribution in our Article 8 of Constitution of Brazilian Constitution to finance the so-called Confederated Union system, composed in Brazil by confederations with national scope, federations with state or provincial scope. For example, in São Paulo, my state, we have an union for lawyers, but we have a federation for workers in banks. So we can have in a state an union, so one entity for the workers in all states, or one federation that congregate several unions in the same state, as in the case of the workers of banks in the state of São Paulo. This is the federations, state or provincial scope, and the unions with local scope. We had 2 assistance contribution. In this case, the provision, the legal provision, is in the Consolidation of Labor Acts in Brazil. The extensive contribution is established in collective agreements as a way to pay the union for achievements in negotiations. Unions haven't wanted to charge non-unionized workers, which indirectly offended the principle of freedom of association. Non-unionized workers paying a contribution to the unions. That's a problem in the concept of freedom of association. But our Supreme Court has rejected this interpretation recently. So the comprehension in our constitutional court today is that it's possible to oblige the workers non-unionized to pay assistance contribution to the unions of his categories, of their categories. And we have to the associative contribution. That's the more common monthly membership fees paid by the workers unionized. We had recently change in union contribution in Brazil by the labor reform in the year 2017. That's called 2017 labor reform, the act or law 13,467. This law, this act, this federal act, made union contribution, this tax, these union taxes, optional for the workers. So before the labor reform, it was mandatory to pay this tax. The workers monthly had a deduction for this tax in their payments. Now, after the labor reform, the worker must expressly authorize in writing and advance any deduction. It's an option of the worker at this moment in Brazil. But this change has consequences. It's the impacts of our labor reforms. Because the workers now pay the tax with prior authorization, work must expressly consent. It's common that workers now don't pay taxes for their respective unions. And include union must ensure deduction on from those who opt in. And improper deductions generate labor lawsuits against the unions. So the institutional impact is great. We have reduction of resource, weakened mobilization capacity of these unions. The estimative, that is 90% drop in financial collection because of this change in our legislation about financiation of unions. Because now, I repeat, contribution became optional. And our Supreme Court, our Constitutional Court, in the year 2023, authorized charging of assistance contribution. So this third form of contribution, our Supreme Court authorized the payment of this assistance contribution even from non-members, non-unionized members of the category. This is a new possibility of financiation because the union tax now only exists with the workers' consent to pay. But in the case of the assistance contribution, with this character that I said, so to pay the union for achievements in negotiations, in collective negotiations, in this case, the unions can have these payments from non-members workers of the category. Finally, about functions of unions in Brazil. Reading our constitution, we can identify 4 main functions of unions in the Brazilian system: the representation function, the negotiation function, the assistance function, and the economic function. The most important in our reality is the representation function, because the unions in Brazil can guarantee the labor rights in 2 ways of procedural representation. In this case, the union can use your condition representing the category as a dispersonalized procedural party. So the party in the procedure is the union in representation of the workers. But there is another way, is the procedural substitution. In this case, the union speaks in its own name, but in defense of other rights. So if the workers have in the work environment problems about security and health, labor security and health, the union can, in a justice actuation, obtain a right to improve the health conditions in this work environment, representing in representation of the workers in this work environment with problems, but in defense of other rights and not in defense of the own rights of the union. So, two ways of actuation in justice, in procedural representation and in procedural substitution. Negotiation function is or would be the most important function of unions in the world, because the ideal in a legal democracy, in the states where we have a political system of democracy, is the agreements, the collective agreements to guarantee social rights to workers. And unions in Brazil have this function by the law. Assistance function is because this function that we have the assistance contribution. The assistance function has legal provision in the consolidation of labor laws, and because that Brazilian unions must maintain social and judicial services, literacy schools, credit and consumer cooperatives, and other possibilities for their members. Assistance function. And economic function. This is controversial in Brazil too. Unions cannot carry out economic activities in a strict sense. Therefore, they are prohibited from having their own banks, for example, unlike in Germany. In Germany, confederations of workers can have banks. In Brazil, it's not possible. And we have discussion about a potential political function for unions. By law, unions in Brazil cannot carry out activities typical of political parties. This rule, I said, is currently under discussion because the Constitution guarantees, for example, workers the right to decide what interests they want to defend with strikes. So if our Constitution said that workers decide what interests they want to defend with strikes, we can have in Brazil, by the Constitution, political and solidarity strikes in thesis. This genre of strikes, these forms of strikes, political and solidarity, are theoretically possible in Brazil, but is controversial. Our conclusions about the Brazilian system of unions. Firstly, the same that Professor Cochrane said, unions are essential for effectiveness of social rights. The second point, we have in Brazil now, in my opinion, an ineffective union protection model. And because of, we Brazilians are not able to sign the ILO Convention 87 because we don't have really in Brazil union freedom. And the third point, the difference, the distance between the rhetoric, the words, and the practice, and the reality There is a poet, a famous poet in Brazil, maybe the best one, by Minas Gerais, a poet called Carlos Drummond de Andrade. In one poem, Andrade said, I no longer want dictionaries consulted in vain. I want only the word that will never be in them nor can be invented. You mean less empty words. What we have in union law, in collective law, in labor law, in Brazilian labor law, is more meaningful action in labor relations. Thank you very much.
Thank you, Professor Guilherme. It's never easy to explain the Brazilian trade union system, especially to foreigners, but you did it in a very clear way. Thank you very much for your participation. We now have a break of almost 1 hour. We expect to be back at 3 p.m. Brasilia local time, 2 p.m. Washington local time. So see you in a moment. Professor Guilherme, once again, thank you very much for your participation.
Thank you very much, Professor. Thank you. Bye-bye.
Hello, Jeff. Hello, Liz. Thanks again. Thanks for your punctuality. And thank you for accepting the invitation. I was talking in few minutes ago with Professor Jean-Michel Servais, and he told me you were together in Rome, I guess.
Yeah.
You met each other
Yeah,
in
ISIL meeting there, yeah. That's a good conference.
Thank you.
Rome
thank
doesn't
you.
hurt as a destination either.
Yes, always a good place to go. Definitely.
Although I love Brazil, so if we want to do something there, I'm more than happy.
Have you been to Brazil? Not yet?
Many times.
Many times.
Yeah.
São Paulo, Rio.
Sao Paulo, Rio, Brasilia, Salvador,
Salvador.
Porto Alegre.
So you know a lot. You know a lot.
Eu falo
Okay.
pouco português também.
That's really good. That's really good. Next message we'll exchange in Portuguese. If you prefer, if you rather prefer,
No.
it's up to you.
I think I'll stick to English for everybody's sake.
Okay. Well, we are right on time, so let's start again. This is our second panel. This one is specifically about the American and Brazilian trade union systems. I'm really proud to present here, to receive here and to present Mr. Jeff Vogt. I have his curriculum here with me. He is Rule of Law Director of the Solidarity Center and co-founder of the International Lawyers Assisting Workers, ILAW Network, member of the ILO governing body. Previously, he was legal director of the International Trade Union Confederation. And before joining the ITUC in 2011, he was the global economic policy specialist for the American Federation of Labor and Congress of Industrial Organizations, and later the deputy director of its international department. Previously, he represented trade unions in litigation in U.S. state and federal courts. He's a graduate of Cornell Law School, where he earned his JD and LLM in International and Comparative Law. He also studied international law at the University of Paris, and he currently is also a member of the ILO governing body. Jeff, thank you very much. Professor Jeff, thank you very much for accepting this invitation. It's a great honor to have you here with us. The word is yours. Would you like to share anything, to share PowerPoint?
Yes, I will share my screen for a PowerPoint.
I'll make you co-host so you can do it yourself.
Right, thank you. Thank you, and thank you for the invitation. And I'll first say with my remarks, I'm trying to cover the whole scope of U.S. collective labor law in 20 minutes. So I will obviously be very superficial and not have a lot of nuance, but I'll try to give kind of overview. So you can. Sorry. You see the screen?
Yes.
Okay, great.
It's perfect.
Right. Okay, so I thought I would start with a very brief introduction to how we got to where we are in the United States. And like many common law countries, obviously the U.S. Initially taking much of its early law and jurisprudence from the United Kingdom. In the 19th century, most collective labor action, whether picket strikes, boycotts, were treated as common law criminal conspiracies under state law. So in the early days of trade unionism, it was literally a crime to be a trade unionist. this changed in a very famous case in Massachusetts, Commonwealth versus Hunt, in 1842, where we see a shift from criminal conspiracy to civil conspiracy. It's not much comfort. You still in many cases your action is deemed illegal, though not criminally. So this still allowed for employers to seek civil injunctions against collective action, with courts being really all over the place as to whether the intentional infliction of economic harm, as it was understood as being a kind of an intentional tort, was justified by the legitimate purpose of the workers with regard to their employer. We see federal courts stepping in, especially with the passage of the first antitrust legislation in the United States. So we have the Sherman Antitrust Act, which was used to obviously prohibit illegal restraints on trade. Unfortunately, very early on in the process, they decided that much of trade union action was also an illegal restraint on trade, with the famous Danbury Hatters case, where the Supreme Court found that a boycott of stores that sold hats from a struck employer violated the Sherman Antitrust Act and imposed triple damages on the workers. There was yet another effort to try to limit union liability under the Clayton Act about 13 years later, which also was read to be very narrow by the U.S. Supreme Court. And then with the 1932 Norris LaGuardia Act, finally preventing federal courts from issuing injunctions in labor disputes that were not violent. So this is the kind of the trajectory of the U.S. labor law before labor law, and where things were where economic relations were largely at the state level before the rise of the anti-competition law. So with that, in 1935, we get the Wagner Act, the National Labor Relations Act, part of the Roosevelt New Deal, which applies to the private sector, and it creates an affirmative right for workers to organize, bargain collectively, and take concerted action, which is a term of art under the law, and also specifically prohibits certain unfair labor practices, such as employer interference, employer company unions, anti-union discrimination, among others. I think it's important to note that there were a number of exceptions that were made at the time in 1935 that had, certainly a kind of racist and gendered foundations, namely in excluding domestic workers and agricultural workers from the scope of the National Labor Relations Act. Supervisors are also excluded from the act, and there's a lot of litigation over the years as to who qualifies as a supervisor. And those who are independent contractors are also not covered by the National Labor Relations Act. And this especially now, as we're looking at more and more workers in working for digital platforms or other kind of forms of kind of mediated employment, are changes depending on which political party is in power and has control over the board. So this is a very live issue now. There are also a couple of other exceptions. Railway and airline workers are covered by a separate law, the Railway Labor Act. And then public servants or civil servants are covered by separate federal or state public employee laws. So I'll be really focusing on the National Labor Relations Act, recognizing that these workers are either not covered or covered by separate laws. In some cases, states have stepped in to the breach and have passed laws protecting farm workers' right to associate and bargain collectively, such as in California and New York. And some states have also stepped in to regulate the terms and conditions of domestic work, but still uneven at the state level. But not long after the National Labor Relations Act was in force, efforts were made to kind of weaken its effectiveness. So you see in 1947, the introduction of the Taft-Hartley law, which was passed over a presidential veto, which prohibited secondary boycotts, jurisdictional strikes, and strikes to enforce a closed shop, which would be, you had, in order to work at a workplace, you would have to be a member of the union. And it also created an affirmative right to refrain from engaging in concerted activity. And then in 1959, Lanham-Griffin was passed, which largely required certain financial disclosures and procedures for union elections, and a union member Bill of Rights were included in the Lanham-Griffin. And that's pretty much where we have been since then. But the core of the National Labor Relations Act, now being 90 years old, is still the basis of U.S. labor law. Just quickly to give you an overall structure, and the board is headquartered here in Washington, a couple of miles from here. It has normally has 5 board members. Now the board only has 2 members, and depending on the day of the week, 3 members. 1 member, Member Wilcox, was dismissed illegally, and the courts have joined and unenjoined her reinstatement back to the board. Importantly, with only 2 members, the board is unable to function at its level. The functions below it can still proceed, but as I'll get to later, there are important functions of the board that cannot continue. There's also the Office of the General Counsel, regional directors, and administrative law judges. So these are kind of the 4 core elements of the now. The General Counsel is responsible for investigating and prosecuting unfair labor practices and representing the NLRB in court. And I'll get to in a moment. Board decisions are not self-executing and need to be taken to a federal appellate court for enforcement. So regional directors answer to the General Counsel and do most of the routine cases, as well as representational elections, which I'll get to in a minute. So if a worker has an unlawful dismissal of a worker for trade union activity, then a lawyer will be assigned to prosecute the matter before an administrative law judge. But most of these cases, the vast majority of these cases, are settled before going to the ALJ. So the kind of quasi-judicial function of the board is undertaken by these administrative law judges. And if there is an objection or an exception, as they're called here, to their decisions, they are appealed to the board, which can sit as a panel of 3, or in important cases could be the full board. And again, we're at the moment have only 2 members, so the board is unable to exercise this particular function at the moment. And as I mentioned, the board orders are not self-enforcing, and they can be enforced by the U.S. Court of Appeals. Also, appeals from a board decision also go to the Court of Appeals. And then, in addition to having this prosecutorial function from the General Counsel and the quasi-judicial function by the ALJs and the board, it can also engage in rulemaking and change the direction of the law through a rulemaking process, which it does through a kind of issuing a draft rule and then sending it out for notice and comment, and then on the basis of that, issuing a new rule. So that's in a very quick nutshell, the basic structure and functioning of the board. Yeah. So I would just say one last thing. There are a number of companies now that have filed a lawsuit arguing that the National Labor Relations Board, as it is set up, is unconstitutional. That's still being pursued, including by SpaceX, which, as we all know, is owned by Elon Musk. So how does one form a union in the United States? We'll talk more specifically here about forming a union for the purposes of being a bargaining representative. Technically, under the law, two people can take concerted activity, and even in some cases, one person can take concerted activity. But for the purposes of having a union and being able to bargain collectively, then there's a process for that. So again, very quickly, given the time, a union would file a petition with the National Labor Relations Board, which is supported by a substantial number of members, roughly about 30%. And this is demonstrated usually by signed authorization cards. Like organizers will have gone to members in the workplace and got them to sign on, yes, I'm interested in becoming a member of such and such union. The way that the U.S. labor law is that the union must seek to represent all the workers in an appropriate bargaining unit. This term appropriate bargaining unit is frequently litigated as to what its scope, and there's a multi-factor test, which I won't get into, but it's employees who share a common interest in terms of conditions and employment and who are best suited for collective bargaining together. But again, that's open to a lot of interpretation. In the absence of an election agreement, again, the regional directors will have issues having to do with the election and the unit and all of those issues litigated. There have been some efforts in the Biden administration to kind of move the timing as to when these issues are addressed, in large part because if an employer decides not to voluntarily recognize a union on the basis of a card check, it sets a formal NLRB election process, which can be lengthy and gives the employer substantial time to intimidate workers to not support the union. And I can go into more of the employer tactics in this point, but because NLRB remedies for like a legal dismissal of kind of a union organizer, of union leaders is quite weak. It has been for a long time considered kind of the costs of doing business by employers just to terminate a worker's, a union activist's employment, with the worst consequence being that months or years later having to rehire them and paying them back pay, as the remedy, the full remedy. Under the Biden board, in a CEMEX decision, the board found that if an employer engages on an unfair labor practice after a petition is filed, they could instead say, well, we don't need to election. We are saying that the employer must recognize the union and bargain with it, which is a very important new precedent. We'll see how long that lasts under the current board. Again, just quickly, and I'll just touch briefly on collective bargaining, and on the next slide on concerted activity, and then kind of turn it over for the Brazilian portion of this. But under the National Labor Relations Act, parties have an obligation to bargain in good faith. And this is viewed as an obligation to meet and discuss, right? But it is not an obligation to actually come to an agreement, which is, in part why we have quite low union density or collective bargaining coverage. You could have bargaining go on for months or years without result. Another issue that's unique but peculiar to the United States is that most collective bargaining takes place at the workplace or enterprise level. There's really no meaningful framework in U.S. labor law for industrial, sectoral, or sectoral level bargaining. So if you have to negotiate workplace by workplace, that is obviously a slow and laborious process. We see it now with the Starbucks organizing workplace by workplace, hundreds of times, and now trying to organize a enterprise-wide collective. So you have collective bargaining pushed really down to the lowest level. You also have this concept of mandatory and non-mandatory subject to bargaining, which comes from an earlier Borg-Warner decision from the 50s. And mandatory subjects to bargaining are those related to wages, hours, and other terms and conditions of employment. And this distinction is critical because if you were to strike over a non-mandatory or kind of permissive subject to bargaining, that collective action is not protected by law. At the same time, if an employer decided to insist on a permissive subject, that would also be a refusal of bargaining in good faith. And just a couple of other things to mention here. A common feature of many U.S. collective bargaining agreements is a kind of no strike for arbitration agreement. So this is during the lifetime of an agreement. The union will say, well, we will not strike over issues arising under this agreement. However, you will have to agree to a binding grievance and arbitration process. So that usually creates a kind of a law of the shop that's developed by of arbitrators who can then hear disputes under the agreement and render decisions which both sides are bound by. In some larger enterprises or industries, it could be a more permanent arbitrator, and others will change from case to case. And as a result, in the United States, we have a very kind of detailed common law of arbitration decisions, which have developed and are frequently cited in arbitration hearings. And then, failure to bargain or surface level bargaining can result in a bargaining order, but the legal process can also be very slow in the US. So not giving this a lot of teeth. And then finally, this idea of concerted activity. It's again, could be activity by 2 or more people. And again, in some cases, it could be one person who's raising an issue of broader import than issues of concern to that person alone. I'll here only talk about strikes. There's picketing and other forms of action, which have a very complicated jurisprudence around them. But Section 7 of the Act guarantees the right of workers who engage in concerted activities for mutual aid and protection. I think what's interesting here is this can be asserted by union or non-union workers. So in this case, it's kind of an individual right, though once there is a union, it becomes more of a collective right of the union. The lawfulness of the strike will depend on the object and purpose, and sometimes on timing, or obviously on the conduct of strikers if it becomes violent, for example. There are 2 kind of lawful objects of strikes I'll mention here. One being an unfair labor practice. The employer engages in unfair labor practice, and unless there's other prohibitions, strikers would have the right to strike an employer over an unfair labor practice. And importantly, they would have the right to reinstatement for an unfair labor practice strike. So when the strike ends, they're entitled to be returned to their work, even if in the meantime, and this is a peculiarity of US law, the employee hired somebody else as a replacement during the strike. So the law does allow an employer to hire replacement workers, but if it's an unfair labor practice, that newly hired worker has to be displaced by the striking worker to be going back to their job. If it's an economic strike, so you're trying to gain an advantage over an employer during like higher wages in the context of collective bargaining, the employee still retains their status as employee and can't be fired, but under US law can be permanently replaced, which is really a distinction without much of a difference. Technically, you could be kind of recalled, essentially being put off on a kind of a layoff list. But you could find yourself at the end of a strike without work. And then there are some kinds of strikes that are just not protected at all. Not shocking. There are particularly effective strikes like the sit-down strikes we saw in the early 20th century in the auto industry, where workers would sit down at their place of work and occupy the workplace as a means of leverage over the employer. So I will stop sharing there, and that is my really, really fast introduction to US collective labor law. So I hope that was useful.
Thank you very much, Professor Jeff Vogt. It was excellent. It was excellent. Very, very clear, and indeed very, very. I know it's a hard task to sum up so many informations in a small amount of time. Now I'll try to do the same. I will start with a brief presentation of the Brazilian model of Brazilian system. Let me just try to share with you the whole presentation. Okay, I think now it's good. Let me just explain. This painter is from a very well-known Brazilian artist called Tarsila do Amaral. It's called Workers. I chose it on purpose precisely to share with you this very, very important remark of Brazilian arts. And before anything, I'll just try to complement some things that our colleague Guilherme Feliciano explained about the Brazilian union system. That is indeed really strange, really strange. I complimented him, I greeted him precisely because I had hard times trying to explain the Brazilian trade union system for foreigners. And one of the main reasons that make this system so strange is precisely because we still have remains of the authoritarian model adopted by Getúlio Vargas in the Vargas era. This model was inspired in Carta del Lavoro from Benito Mussolini. It changed little from the 40s of last century until 1988. But even in 1988, the changes were shy regarding what we were expecting. So we never reached a real freedom of association as defined by the Convention 87 of ILO. So basically, what is the Brazilian trade union model? It's a model based on one presumption. What is the presumption? That workers should be represented by the same union. All categories of workers should be represented by the same unions, and all categories of employers should be represented by the same employers association. In Brazil, we call it also employers unions, but I know that this word is not correct in English. So the main idea is that we created legal presumptions. So if you work in a supermarket, our law presumes that you should be represented by the same union that represent all workers in supermarkets in that union, in that city, in that region. It depends on what the workers decide as the base of this union. And in the same way, if you start a supermarket, if you are the owner of a supermarket, your economic interests should be represented and defended by the same employers organization that would represent all the other owners of all the other supermarkets. So it doesn't matter if you are a supermarket destined for public A, B, or C. It doesn't matter if you are an online supermarket or a real estate old school supermarket, you should be represented by the same employers organization. But in the case of workers, we have another particularity. In some cases, our law presumes that some activities, some professional activities are so similar, even in different economic bases of employers, that they should be represented by the same differentiated professional union, trade union category. Let me give you an example that I think will clarify what I'm trying to explain. The workers in the supermarkets in the same region should be represented by the same union. We don't allow one union for each supermarket. It must be one union for all employees in supermarkets. However, if one supermarket decided to buy trucks and hire as employees truck drivers, those truck drivers should be represented by the same union that represents truck drivers from universities, truck drivers from banks, truck drivers from how can I say, housing enterprises, because our law presumes that the truck drivers, they have similar activities, even if they are hired by employers in very, very different economical activities. So this is what we call category. Category in our law definition is a community of interests that justify the establishment of organizations composed of members engaging in the same economic activity, what we call economic categories, or of members working in the same field of activity, professional categories. But regarding professional categories, we have inside them a particular group that we call differentiated professional category. This definition is for the category of employees engaged in different professions or functions by virtue of special professional status or as a result of special living conditions. Truck drivers should be, or actually drivers should be one example of differentiated professional category as a result of special living conditions. And lawyers should be an excellent example of differentiated professional category by virtue of special professional status. One lawyer that is an employee in a law firm, one lawyer that is an employee in a supermarket, and one lawyer that works as a lawyer for a bank, they should all be represented by the same union in that region. That is the lawyers' union. Okay, and as Guilherme explained brilliantly, we have one particular rule that doesn't allow a second organization per category. So we are not allowed to create more than one workers union or employers organization at any level to represent the same professional or economical category within that territory, within the same territory. That means that if there is already one union to represent professors in the municipality of São Paulo, I cannot create a new one, even though I don't agree with the politics of the union that exists for me. So I have only one option. Our freedom of association only allows me to say yes or no to the union that was created to represent my category. I can say no, and I won't participate in the politics of the union, and I won't use the services provided by the union. Or I can say yes and participate in the politics and use the services. However, if I say no, whatever is collective bargaining by the union that represents my category shall impact in my work, shall impact in my wages, shall impact in my work conditions. So even saying no, I I'll have to follow whatever the union that represents my category shall decide. And let me talk about my main topic that is precisely about collective bargaining. In Brazil historical model, the role of collective bargaining, and actually in most of civil law countries, the role of collective bargaining is not to create the labor law, but to regulate labor conditions for workers within a specific occupational category of company. What I'm trying to say is that in countries that follow this civil law traditions, we normally have a code. In Brazil, we call it CLT. It's actually a consolidation of ancient laws. But in the civil law tradition, we have a code that try to anticipate all the problems that can be created in particular situations. Since the Napoleon Code, the Civil Code of Napoleon, we have this idea that we try to anticipate, we try to create a whole bunch of rules that would solve the problems that may or may not happen in the future. So, in the civil law tradition, we have large codes. For example, Le Code du Travail français, the French labor code is one great example of a very detailed, well-detailed labor law code. In Brazil, we have our CLT, and the role of the collective bargaining is to try to particularize, try to look for special needs of those categories. Let me give you one great example. I'm a professor at São Paulo. We have our union from years now, from decades actually now, negotiate year after year with the association that represents workers, negotiate a clause that we called semestrality. What does this clause says? It says that it states that professors cannot be dismissed in the middle of the semester. If the university or the school wishes to dismiss a professor, it must do it before the vacations, the collective vacations of July, or before the yearly break of January. If the university or the school doesn't comply with this rule and dismiss a professor in the middle of the semester, the professor is entitled to receive all the wages of the remaining period. Why is that? Because normally professors don't find new jobs, new work positions in the middle of the semester. They must wait until the yearly break or must wait until the vacations to find a new job. So for a professor, this semestrality is extremely important. But should it be written down in the Brazilian labor code? No, because we're talking about a particularity that belongs precisely to this category. So there is no need for semestrality for bank employees, for truck drivers. Therefore, it shouldn't be written down in our general and universal law. This is the main idea of our historical model. Since this was to try to find these special needs, the general rule was the collective bargaining should always look for better conditions than those provided by the law, provided by the codes. The idea was always to increase the protection of workers through the collective bargaining and not to reduce or to flexibilize, to make it more flexible, the rules stated in the law, stated in the codes. It was the main idea, and it was worked properly until 2017. But before telling this, what we normally negotiate, we negotiate collective agreements. And in Brazil, we have two kinds of collective agreements that can be searched. One of those we can translate as collective bargaining agreements. They are entered into between workers' organizations and one or more companies. In Portuguese, we call it Acordo Coletivo de Trabalho. And what is the effect of this collective bargaining agreements? It will be applicable only to employees of the companies that have signed it. Not only those employees that are members of the trade unions, but to all the employees, being affiliated to the union or not, but all the employees of that company or of that group of companies that participated in collective bargaining. We also have the collective labor conventions that are entered into between workers' organizations and employer organizations, and they apply to all employees who provide service to companies whose employers' organizations have participated in the negotiation. Let me give you one example. If we have a collective bargaining between the trade union that represents bank employees of the municipality of São Paulo and of the employers association that represent the banks that are established in the municipality of São Paulo. The result shall create rights, obligations, and punishments to all the workers of all the banks that are established in São Paulo, if they're not a differentiated category, right? But in this collective labor convention, will create rights that would be entitled to workers that are member of the trade union system, and to those that are no longer or never have been members of the trade union systems. Normally, what is the main idea? Unions, the trade unions that represent workers, start bargaining collective labor conventions with the association that represented the employers. They create the general rule, like the minimum wage for the category. We call it in Portuguese, piso salarial. What would be the wage adjustment to compensate the losses imposed by the inflation of the period. And after that, the trade union search for certain companies that can provide a bigger raise, or can provide more rights for the workers to negotiate a collective bargaining agreement. And some subjects, normally they must be negotiated in collective bargaining agreements. I think the best example possible is what we called share of profits with workers, participação dos lucros e resultados. And why I think this is the best example possible, because it's not reasonable to negotiate share of profits of the same standard to all the companies of one sector, if we must recognize that it's possible they didn't have the same result, the same profit. Let me just give you one example. In 2016, Itaú, a huge Brazilian bank, had a huge profit. In HSBC, the British bank that was until then established in Brazil, faced huge losses. It would be reasonable to have the same share of profit, the same rule regarding share of profits between those two banks? Of course not. This is why those kind of subjects normally are negotiated in collective bargaining agreements negotiation and not in collective labor conventions. And just to sum up and to remind you, prior to November 2017, collective bargaining agreements and collective labor conventions could only establish working conditions more favorable than those prescribed by law. Actually, the collective bargaining agreements, since it was normally done after the collective labor conventions, it should also establish working conditions more favorable than those prescribed by the collective labor conventions. So the idea was always was that of a constant progress in looking for the best working condition for the workers. What happened in 2017? The Employers Association finally got something they searched for many, many years, I would say decades. That was the idea that the collective bargaining shouldn't only increase the working conditions, but could also, for example, reduce some rights or establish less favorable rules than those established in the law. This discussion started in the 80s when our constitution allowed in two very specific situations, the two very specific flexibilization to fight and to try to face in the best possible way economical crisis, inspired in something that happened in some European countries during the 80s, mainly in Germany. Our legislators stated in our constitution that wages could be reduced through collective bargaining, and that work hours could be changed and even reduced through collective bargaining. What was the idea? Was to create the possibility of collective bargaining as a tool to face economical crisis, to establish the idea that sometimes the collective protection is better than the individual one. So if companies are facing crisis, if one economical sector is facing a huge crisis, and companies are about to dismiss 30–40% of its workers, the union could try to use the collective bargaining to save the work positions, to save the jobs, reducing the wage of all workers. Is the idea of collective protection. It's better to have all the workers receiving 40% less than to have 40% of the workers unemployed due after collective dismissal. So this is the main idea regarding what was stated in our constitution in 1988. However, some very well-known professors and some employers, employers association, they tried to propose, they proposed an interpretation that if the Constitution allowed the reduction of wages and the reduction of work hours, and those are the most important obligations in the labor law, everything could be reduced through collective bargaining. The idea was whoever can do the more can also do the less. So if you can reduce the most important obligations, you can dispose in different way and even reduce all the other obligations. This interpretation wasn't well received by the Brazilian courts, and was subject to a law project in the beginning of the 2000 years, in the time of Fernando Henrique Cardoso as president. It didn't succeed, but after the impeachment of President Dilma Rousseff in 2017, during the government of Michel Temer, they approved what was, in my opinion, not what the most proper way called negotiated over legislated rules. The basic idea was to allow collective bargaining to reduce rights and not only to increase them. And one thing that is very important to share with you is that in the beginning of the project, the idea was to have a list of situations where the collective bargaining could reduce rights. And the idea was that that list would have not examples, but it would be what in Latin we would say numerus clausus. It was a rigid list, and only in those situations we could use the collective bargaining to reduce rights. This was the original project. But what happened is that during the discussions of the project in the parliament, realizing that they have many more votes than they needed, they decided to change a lot the project, and changing from one idea, when initial idea was we have this brief opportunity. Let's change anything that bother us, but let's change whatever we can. We cannot miss this opportunity. And during the legislative process, they realized they had so many votes that they should profit from that opportunity to change everything that bothered them. So it was in that moment that this labor law reform project that was initially called smallest labor changement, mini reforma trabalhista, became the biggest labor law changement in our history, in Brazilian labor law history. And that idea that the collective bargaining could reduce rights only in previously stated situations changed from a situation that the law states some examples of situations where the rights can be reduced through collective bargaining. That's what we can understand reading Article 611A of CLT, that says the collective agreement and the collective bargaining agreement take precedence over the law when, among others, they have, and this is those are examples of the situations that can be reduced or flexibilized through collective bargaining. And if we look for the following article that wasn't stated in the original rule, in the original project, it says it has, in this case, a numerous clauses list of exceptional situations in which it will not be possible to suppress rights through collective bargaining. And this list starts with professional identificational norms, unemployment insurance, and it has some minimum wage, naturally, and it has some situation that represents a lot of risk. For example, it says that the value of the monthly deposits and the severance indemnity of the fund of guarantee of the time of service, FGTS, cannot be changed. The value cannot be changed, but the periodicity can, through collective bargaining. The nominal value of the 13th salary that should be paid in, according to Brazilian law, in maximum 2 payments, the nominal value cannot be reduced. However, the number of payments can be up to 12 or even more if the union agrees. You cannot reduce, for example, the number of vacation days due to the employee, but the law doesn't forbid, for example, the reduction in the payment of those vacation days. So what we can see now is that the collective bargaining that can reduce the rights stated in the law are the rule. In the situations where the collective bargain cannot reduce those rights are the exception. And in my opinion, it has a very, very psychological problem, because until the changement, the general idea was that the collective bargaining for employees was normally an instrument, a tool of gain, of conquest, of small victories. It became a tool that it can become even a menace that they will lose their rights. And this is completely different from what we have, for example, in common law countries, where you don't have the law, you don't have the right until the union can conquer it in a collective bargaining. In Brazil, we have a very, very good example of a similar situation regarding share of profits. The law doesn't say how much should be shared. What is the percentage that companies shall share with workers? If everybody should receive the same share of profit, or if it should change according to the hierarchy. It says the collective bargaining shall decide it. So we only conquer right to share of profits after the collective bargaining. In this case, the collective bargaining is a great example of a tool to create labor law. In our ancient rule, the collective bargaining was always a tool to increase the rights that were already stated in the law. In the new model, we can lose rights due to the collective bargaining. Why I say it's a psychological terrible changement, because now when we come close to the time of the collective bargain, we fear that ancient rights, like that example of the semestrality for the professors, could not be negotiated anymore and could be lost. And this is the worst situation possible, in my personal opinion, to this question. I know that it's already 4 p.m. and I'm trying to cope with the time as in the most strict possible way. So I will stop here. I had many more things to share with you, but I will stop here and to precisely to invite Professor Liz Tippett, Professor Antonio Rodrigues de Freitas Jr. to join me in the third panel that would be about the challenge of protecting workers on digital platforms in the United States and Brazil. Let me just to follow with what we already stated and we established it. I will start with the situation in the United States, inviting Professor Liz to give her lecture. And let me just present Professor Liz Tippett as professor at the University of Oregon and the faculty co-director for the master's program in conflict and dispute resolution. Before joining the faculty, Professor Liz Tippett practiced employment law at the Silicon Valley. She graduated from Harvard Law School and Harvard College. She examines subjects in her research, such as employment practice, consumer decision-making, intersections of law and technology. She published her researches in very, very prestigious journals such as Texas Law Review, Minnesota Law Review, Arizona Law Review, Yale Journal of Law and Technology, among others. And she had received many prizes during her professor's career, such as Hollis Teaching Award, Fund for Faculty Excellency Award, Michael J. Zimmer Memorial Award for a Rising Scholar. And this is just a brief presentation. I could say many more excellent things about Professor Lee, but I would rather listen to her speech, and I transfer immediately the word. Professor Lee, thank you very much for accepting the invitation. The word is yours.
Hi. Well, thank you so much. And I've learned so much today, and also so grateful to Gus and to Jeff for covering all those labor law issues for us. And the explanations were great and perfect. And I've learned so much about Brazilian labor law as well, and I appreciate that very much. So today I was going to talk about independent contractors, and in particular, I was going to describe some of the latest trends that we're seeing in the regulation of independent contractors and attempts to provide better protections for independent contractors. And I think a lot of this is because of the rise of the gig economy, although these trends are not specific to helping gig workers. Let me see if I can share my screen here. Let me start the slideshow. This is always like a high stakes kind of thing. Okay, here we go. Can everyone see my slides?
Yeah.
Okay, great. Let me just move this out of the way. Yeah, that's probably not going to help. Okay. So the main problem in American employment law, and just to clarify for everybody, there's sort of two areas of law in the United States. There's labor law, which we have talked about today a lot. And labor law in the United States is the law around union organizing, collective bargaining, forming unions. Whereas employment law is typically understood to be the law that covers workers who are not unionized. It covers everyone, including unionized workers, but everyone. So today I'm going to mostly talk about employment law. The real problem when it comes to employment law for independent contractors is they usually have no protections at all under employment law. So if you think about the basic American employment law protections, they would be things like unemployment insurance, workers' compensation protections, wage and hour laws, anti-discrimination laws. All of those folks generally are not covered by the statutes because the statutes are usually include a definition of employee, and only employees are covered. And so if you don't meet the legal standard for who qualifies as an employee, then you don't get any of those protections. This has become a big problem. I'm sure as Professor Freitas will provide the Brazilian version, but this is a big problem in the United States, at least in part because many of the gig companies have sort of exploited the fact that these employment laws are specific to employees. And so they have said, well, everybody who works for us is an independent contractor, so they don't get any of these workplace protections. So in response to the sort of rise of the gig economy, there was a lot of scholarship in the United States attempting to sort of address what the problem was and come up with some potential solutions. And I would say generally that the responses tended to fall into three different categories. The main response that American scholars had to the rise of the gig economy is that these workers really aren't independent contractors, that as a legal matter, these workers should have been classified as employees, and these gig companies are just sort of like flouting the law or exploiting a loophole, and they should either be taken to task and forced to recategorize these workers as employees under existing law, or maybe we should change the law to make it clear that these workers are employees. That was like mostly the main scholarly response. There's been like a few scholars who have said, well, we should recognize a third category of workers that are sort of in between employees and independent contractors. And these workers should have some rights, but not all rights of employees. And that idea has actually turned out to be very appealing to the gig companies, which I'll talk about in a minute. And sort of the last idea is that, well, maybe we can protect these workers as independent contractors. Maybe independent contractors of all sorts, not just gig workers, ought to have more legal protections. And there's been actually a little bit of traction on that point. Not much, but a little bit. Especially though by the FTC. The Federal Trade Commission, who has done a lot of work around non-competes, but you can also see them getting a little bit more into the space of protecting both employees and consumers, and also thinking about these independent contractors as consumers to some extent, and also maybe thinking about the companies that employ these gig workers as engaged in unfair trade practices. Because part of what the Federal Trade Commission does is they protect the American economy against unfair trade practices. So there's some like really interesting innovation by the Federal Trade Commission that I will talk about at the very end of the presentation. First, though, I wanted to talk a little bit about what happened with that second category, particularly in California, which I think is kind of interesting in terms of the gig workers, or the gig companies actually trying to advance a third category for these workers. So I don't know if you've heard about this because it's several years old, But in 2020, well, a few years before 2020, California really expanded the definition of employee under California law in a way that made it really clear that these gig workers would have qualified as employees and were entitled to the protections of California employment law. And these laws were enforced against the gig companies, and the gig companies did not change their practices. They were like, well, we just are not going to do what you say, court. And they were actually in contempt of court orders telling them to reclassify these workers as employees. And instead of complying with the court orders, what these gig companies did was they lobbied for a ballot measure that would be presented to California voters. And that was called Prop 22 in 2020. And Prop 22 basically gave these workers some rights, but clarified that they would still be considered independent contractors, and also made it really hard for the legislature to overturn the like limited protections that would be given to these workers. And so I'll talk about what those limited protections were in a minute. But Prop 22 was actually passed with 58% of California voters. It was then declared unconstitutional by California courts because it prevented the legislature from overriding the results of Prop 22 by providing additional protections if they wanted to, as the legislature is entitled to do. But eventually the California Supreme Court said, no, actually, this is fine. The California voters chose this and it's perfectly fine. And you can work around it in various ways. So this was from 2024. This Prop 22 was actually upheld. So the gig companies were actually successful in sort of circumventing California's attempt to bring them within the definition of employee. Here are the benefits and limitations that are available to California workers under Prop 22. So they do have wage-based protections, but the wage-based protections are not as good as minimum wage because they don't have overtime. But also working time is only counted as the time when you're like actually driving, for example, if you're an Uber driver. And so a lot of time that would ordinarily be considered working time under regular wage and hour rules does not count. So even though this seems generous, it's not as generous as it might be. It provides, various other forms of like benefits, sort of. I mean, it doesn't guarantee healthcare, it just gives you a subsidy so you can buy the healthcare yourself on the Obamacare exchange, and then it provides some limited insurance. It doesn't provide unemployment, workers' compensation, overtime, or the right to unionize, which those are often considered some core employment-based rights. So I don't know. Is this a good thing or a bad thing? I think it sends a message that companies can work around these laws if they don't like them. On the other hand, they did persuade California voters that they thought this was a good idea, although they spent, millions, tens and hundreds of millions of dollars advertising this. But I mean, I think it does show that this sort of second category is a viable legal option. Going back to the third category in terms of, well, maybe we should just provide better protections to independent contractors generally. There is a little bit of precedent for that. When Congress passed a bailout package for the entire economy in 2020, one of the things they did was they extended unemployment insurance to basically all independent contractors. So that it was very time limited though, and it was limited to that bailout money. So it's not still the case, but it was an example of thinking more broadly about how to help workers. During the Me Too movement, a few states, not many, California would be the main example, extended some of their harassment related protections to independent contractors. So, I mean, that does suggest that, maybe you could protect all independent contractors, not just gig workers, by just making life a little bit easier for those workers. Another example might be Obamacare. Obamacare was passed in 2010. You might have heard of it. It basically made it possible to buy insurance yourself. Before that, you could buy health insurance yourself, but it was really complicated and there were a lot of exclusions. Like if you had a pre-existing health condition, you usually weren't able to get insurance for that sort of thing. So Obamacare made it possible to be an independent contractor and to find a way to have health insurance. And if you were a low-income person, you could get a subsidy to do that. Obamacare also expanded Medicare, or Medicaid, which is health insurance for low-income individuals. And so that also made it more possible to do independent type work if that's the kind of work that you wanted to do. And this law actually kind of ushered in the gig economy in a way, at least according to the Uber founder Travis Kalanick, and this famous venture capitalist, because it made it possible for people to do gig work if they wanted, but still have a way to get health insurance if they wanted it. And so that's also, a way to think about. I think people ought to be able to do independent work if they want to, and making it more affordable for you to do independent work, I think is a good idea, because you want people to have choices about, how they spend their time and what kind of work they want to do it, and whether it makes sense to choose a form of work where they have more control over their schedule, for example. So I think this is actually a good example of helping people in that way. So the latest thing that we've seen is treating independent contractors in a way like they're consumers. So consumer protection law is sort of the law that governs, any of us when we're buying or selling something in the marketplace. And there are sort of basic protections around those transactions being fair. Because if you're an independent contractor, the main legal protection you have is whatever is in the contract that you have with your person you're doing work for. And consumer protection tends to provide like a few parameters around those contracts. And so one theory, which I think is pretty interesting, is can you protect workers through the contracts that they enter into with these companies? I think consumer protection law is also kind of limited in other ways. But I also wanted to give everyone a case study from my book, my forthcoming book. I'll show you the cover at the very end of the presentation, which actually shows the way in which employment law and consumer protection are related. This is a truck driver named Dominic Oliveira. He told me that he is actually American Portuguese, so there you go. So he was in a really famous Supreme Court case called New Prime versus Oliveira. It was a case brought by a bunch of truck drivers who were classified as independent contractors. It was like 40,000 truck drivers. And they said, well, we were misclassified as employees, and so you owe us like the various minimum wage laws that applied specifically to truck drivers under federal law. But the lawyers were really smart, and they made this sort of alternative argument that even if you don't find that they're misclassified as independent contractors, there are other aspects of their arrangements with the trucking company that were exploitative and illegal under consumer law. Because the way that this company operated was they aggressively recruited drivers, and they used various like additional sales pitches to get people to sign on as independent contractors. So if you were a driver for this company, it wasn't just that you were working for a set amount of mileage, like you got paid per mile. That's like what they're advertising here, like work for Prime and earn more because you get paid per mile. You also ended up in these other contractual relationships with this company where they would you would rent the truck from them. And so you were paying money to rent the truck. You were paying money for gas from them. You were paying money for repairs. And so, there were a lot of components to this contract itself that was kind of exploitative. There was also a really bad provision for training drivers, where basically if you signed on to the trucking company and you didn't have you weren't certified as a driver, they said, well, you can be certified as a driver through us, but they didn't actually provide any meaningful training. All they did was have the person drive with someone else, a certified truck driver, for X numbers of miles, where they would trade off and drive with the person to get their certification. But the really exploitative aspect of it was they said, well, our training to you is worth $4,000. So if you don't stay on as a driver with us for a year after you're certified as a driver, you have to pay us back this $4,000. So it's basically treating this person's work as like kind of a loan, and it was like a pretty much fake loan because they weren't actually providing any training. You know, sort of like these sort of old historical relationships like indentured servitude, where, you know, you were working for a company to basically pay off a loan that you owed to them. You know, that's very exploitative, and that's not necessarily going to be protected by employment law if these people continue to be classified as independent contractors. So you can see all the sales pitch that they gave them. Dominic Oliveira ended up like really in the hole from working for these folks because ultimately when you took the amount that he was paid per mile and then you subtracted all these other expenses that they imposed on the drivers, like fuels, tires, parts, he was making like $4 an hour, which is really quite a bit below minimum wage. You can see the sales pitch just goes on and on. Yeah, so you can see this is what I was talking about earlier. And I mean, other aspects of Dominic's story were just like totally heartbreaking. Like one of the things he told me was that you know, they make it seem like you're an independent business person, but really like you were losing so much money that you just had to stay out and keep driving on these really long haul trips. And he was also saying that like he really couldn't afford anything, and part of what he was delivering on these long haul trips was like food. And every once in a while the truckloads would get rejected by the customer for whatever reason, non-conforming, or you know, I'm not up on the technicalities of trucking, or maybe they wasn't delivered in time or whatever it was, and they would reject. Dominic Oliveira said that, you know, he was so poor that he would just like eat this rejected food. And so he would say that like, so he said there was one time that like these like Tyson chicken nuggets were like a rejected load that he delivered. And so he like heated up the chicken blocks on the chicken nuggets on the engine block and like ate them because then at least they were free. I mean, it's just crazy. So, you know, and it reminds us a lot of like the American history. We have a long bad history of, for example, company stores where, you know, you would work for a company town and you would buy things at an inflated price at a company store, and they would take it out of your paycheck, and then you would accumulate this debt from buying things at the company store owned by your employer, right? And you'd have to keep working for them. But, you know, in a way, in this situation, Dominic Oliveira's situation, it's even worse because, you know, you're not just buying like things for your family from the company store. You're not just buying like sugar and flour. You're buying like gas. You're buying like the tools and equipment that you need to perform your job. Like that's typically something the employer is expected to pay for. Yet in this arrangement, like you're actually paying for all of those costs. And it's those costs that are keeping you that like force you to keep working for them, in addition to this sort of bogus training. Anyways, this case happened to have a good outcome. Dominic Oliveira had to litigate all the way up to the Supreme Court because the employer said that he was covered by an arbitration provision. Turns out there's like an exclusion in the arbitration law at the federal level for interstate truck drivers. So the Supreme Court said you're not bound by arbitration. They were able to proceed, and they eventually settled for $28 million. But the other smart thing, as I mentioned about these lawyers, is because they challenged those training provisions. They, in addition to getting payment for these drivers, the company agreed to release the drivers from liability associated with that fake training program, and to notify the credit reporting agencies about it, because if you didn't pay back that money, they would, you know, report that you owed them a debt, and then that would affect your credit history. The FTC, the Federal Trade Commission under Biden, you know, I think it's too early to say what Trump will do around the FTC. They have surprisingly like not reversed as much of the Biden administration policy at the FTC as you would have expected. So I don't know what will remain from the FTC policy. But one of the things that the Biden administration did is they said, hey, even if these gig workers are still gig workers, a lot of these companies are making false claims about how much money you can make as a gig worker, and that's a form of unfair competition. And they had planned to issue regulations that required these companies to disclose what the true terms of the payment would be and what you could actually expect to receive if you worked for them. Those regulations haven't been issued yet, so probably it's not a priority for the Trump administration, and I don't know how much the Trump administration has defunded the FTC in any event, so even if they were inclined to pursue it, they may not be able to. But I do think that it's a really interesting area. Jonathan Harris, who's a scholar here in the United States, does some really interesting work looking at the intersection between consumer law and work law. And, you know, I think it will be increasingly important for employment lawyers to assert claims both based on consumer-based theories and employment-based theories when you're trying to get a remedy for these independent contractors. I would say that there are some downsides to, this is the disclosure rule that the FTC was thinking about imposing. They still have these policies on their website. I don't know how long they'll be there or if the FTC still cares about it, but I think it's good to know that it's still there. I do think there's downsides to using consumer protection law. You know, consumer protection covers all of us. So it's notoriously under-enforced. It's really hard to find people who specialize in consumer protection law. You know, the protections under employment law are much more robust, and, you know, they are preferable if you can make use of them. The other problem with consumer protection law is it relies heavily on disclosures as opposed to providing substantive rights to people. So, you know, it may be that, like, for example, the FTC says you have to make better disclosures about how much money you can make as a gig worker, but doesn't actually require them to pay minimum wage, for example. So, you know, it's unclear whether people actually act on those disclosures or not. Here's the cover of my book, which covers like a lot of the legal history that I talked about. It talks about, it has a chapter on labor law. It also has a chapter on this sort of gig work stuff at the end. It covers a lot of legal history in the United States. It's currently only available in English, but if there's a market for a Portuguese translation, I'm sure that the publisher would love to publish it in Portuguese. If you order it on the website, here's a coupon code where you can get 30% off if you want. Yeah, but that's all I have for everyone. Thank you so much for being here, and so excited and honored to be, you know, part of this group.
Thank you very much, Liz. It was a really, really brilliant presentation. I'll already ask your authorization to publicize your new book in our circular letter with the permission of our president that is here hearing your speech. And now I have the honor to present Professor Antonio Rodrigues de Freitas Jr., my professor. I'm quite happy with the possibility of seeing him here with us again, and trying to sum up all his qualifications. Professor Antonio Rodrigues de Freitas Jr. earned his bachelor's degree in law from the University of São Paulo, where he also completed his master's, doctorate, and postdoctoral qualification. We call it in Portuguese livre docência. He is currently an associate professor of labor law and human rights at the University of Labor Law of São Paulo Law School, Lago São Francisco, since 2002, where he teaches, conducts research, and develops extension activities with an emphasis on labor and digital technologies, social protection for migrants, and conflict mediation. In the field of conflict mediation, he was awarded the Conciliar Legal Higher Education Prize 2017 by the National Council of Justice of Brazil. He served as National Secretary of Justice at the Ministry of Justice, 2002, a Legislative Council for the City of São Paulo, appointed through a public examination in 1991. and he was the first director of the School of Parliament of the São Paulo City Council, and its executive director until 2017. Professor Freitas, thank you for accepting our invitation. It's a great honor to have you with us.
Professor Jorge Boucinhas, Professor Michel Servais, my dear Professor Listip, it's very, very good, very nice opportunity to see you again, though by this by the screen. But anyway, just prior to start my presentation, it's not exactly a presentation, it's just some tips I tried to jot down in order to face the challenge of the challenging how to regulate gig workers. But prior to this, I would like to also, likewise, Professor Listip said, I'd like to present you this book that was the result of a seminar, international seminar that took place here in São Paulo, and was coordinated by myself, unfortunately, but also, I would say, very proud, by Professor Listip. She was one of the coordinators of this seminar. And then finally, we have this book, sort of putting together some of the contributions, some of the reflections that we took, that we had the opportunity to go through this during this meeting. Professor Lees, I never thought so seriously about to put together some reflections about regulating gig workers, with regulating by means of consumer law, but I'll take it more seriously from now, because I think we could find some very interesting paths to go through, and to sort of try to turn around and bypass the obstacles that we are facing, and the traditional agenda of trying to fight against misclassification of workers' relationship in the gig economy, basically in the workers by on-demand platforms. The theme, the issue of this session was challenged in protecting workers. And the first thing I would like to put under consideration is that, to what extent I think our society does want to protect workers. I mean, to what extent do we have currently a social agreement, a social consensus that workers should be protected? It could be some dumb question, probably a couple of decades ago, but if we take a look at what's going on in the political atmosphere around the world, and I'm not going to stumble on the North American administration or in the Brazilian administration, very, very close to us in the last administration. But if we look around, we see a very strong prejudice against protecting workers and strengthen legal protection towards labor and employment relationships. So I would rather be wrong, but I think this is unfortunately what we are facing currently, not only in Brazil, not only the white urban middle class of Brazilian big cities, but also in different countries and different social segments. So if we have a consensus, if we have the idea, if we have a society that intends to regulate it and to give protection to workers in the gig economy, the second question I think we have to face is, to what extent the workers themselves when to be protected. I mean, just let me incidentally tell you about research that a supervisee, a master student that she has already finished and presented her dissertation, master dissertation, was basically interviews with gig workers, especially delivery workers and drivers in the platform economy, on-demand platform economy. And most of the interviews sort of certified that the workers themselves don't identify themselves. They don't have the identity of being employees or nor being strictly workers. Some of them refer to themselves like if they were what I would say entrepreneurs. Can you imagine a boy in a bike or even a motorcycle in the center of São Paulo, hard traffic downtown, so delivering some pizzas and seeing him or herself like entrepreneurs or entrepreneurs. It's for me, it's something very, I would say, if not bizarre, very unpredictable. If we look at what we had, like the idea of workers trying to fight for the recognition of the rights and the recognition of the pride to belong to the workers class. It's not what we are. Unfortunately, it's not what we are facing currently, as far as I can perceive, and as far as I can realize by means of some interviews that were carried out by academic research that I was supervising now here at the University of São Paulo School of Law. Well, it's very difficult to protect workers by means of recognizing their relationship, their work arrangement as an employment relationship, if they don't believe they join a labor relationship and against their will. It's very difficult, I would say. It's impossible. Oh, no, I got it. A third question, a third challenge that I think to be accountable with a theme of this session, of the subject of the session. A third challenge consists of to what extent we should think about, or mostly think about, legal provisions to convey legal protections to the workers engaged in the gig economy, in the gig sector of the economy. In other words, basically and traditionally, the labor and employment law thinks about and propose to regulate and to convey legal protections by means of legal provisions. In Brazil, according to our corporatist tradition, our corporatist and state-guided tradition and heritage, legacy, it's with the importance of the labor courts and so on, as everybody knows. I mean, in this environment, in this academic environment, we think about protection by means of passing legal provisions. And the thing I would like to put under reflection is do we still have to think about only or even in most of the cases, mainly regulated by means of legal provisions. I mean, shouldn't we think about alternatives like collective bargaining as a means of regulating? And I would say conducting an important regulating track towards conveying legal protections for workers in the gig economy. If we look at what's going on here in Brazil, if we look at the Congress, they are very obviously very conservative and very liberal, but not only, they are very resistant to the idea of passing legal provisions towards providing legal protections for workers in the gig economy. But if you take a look at what's going on in the streets, you can see some movements, some important movements, street movements conducted by unions, small unions, very initial movements, but they are enough important to put workers on the streets striking for legal protection, despite the fact that they don't have exactly an agenda to identify what they call by legal protections, and to what extent they think about legal protections by the traditional legal provisions, like fixing limits of hours of works, a day, a week, vacations, and so on. Probably they have some more attention devoted to stuff like how many hours, the length of time they're going to spend during the delivery, and stuff like that. But anyway, I think we have something very seminal to explore regarding the workers' union and the workers' organization and the workers' movements in the streets going on nowadays in São Paulo street and in other important cities around the world, as I could perceive and as I could have some notice, some news about it. The second, even still in regarding the importance and the relative importance, I would say, of legal provisions, I would put under consideration the possible strategy of inducing by state actions, by the public sector inducement for the self-regulation strategies. In other words, we can think about the self-regulation by some, especially by some of the gig companies, because some of them are so institutionalized and they are so concerned about their public their public image that well, I think it could be useful, at least to try to invite them and to induce them to start an agenda, a collective agenda, a bargaining agenda, in the sense of le dialogue social, the social dialogue, devoted to promote a self-regulating code for conduct, not obviously focusing all the the big and very diverse issues involving the gig economy, but at least some of them, such as insurance, legal compensation, such as, for instance, limits for hours and limits for time in the delivery back and forth. Well, I think it could be taken into a more serious consideration. Go a bit further. I would put under consideration if we from the labor and employment law tradition, if we could sort of try to promote an aggiornamento of our traditional legal tools devoted to promote legal protections for workers. In other words, do we still have to be confined by those traditional tools like fixing limits of hours work, fixing limits and fixing minimal wages in terms of minimal amount of money as sort of minimum wage policy, fixing leisure time, life vacations, as I said before. So could we try to think about some other way to promote legal protection that would be, I would say, crafted by different strategies that could be probably a bit more far away from the traditional industrial labor employment relationship and the traditional industrial labor protection. I think we could consider some stuff like what should be the most appropriate way to imposing tariffs. I mean, to put this youngsters, this young generation that is in the streets of the great cities like São Paulo, totally out of legal citizenship, and to put them inside of citizenship by means of integrating them to social security system, but not by means of the traditional way to introduce them to social security and in other words, in the payroll, but probably using some different ways of taxing, imposing taxes, especially imposing taxes for the rich and profitable companies, great international companies that take profit from the workers in the gig economy, for the companies in the gig economy. They are not platforms. They are not a software. They are not a whole bunch of by-hazard clustered algorithms. They are companies devoted to take benefits from the workers' activity, and they are companies competing in the market and trying to become more and more rich, profitable, and competitive. In other words, they should be treated as companies that take benefit from this business. This is a business. This is not a platform neutral intermediation. It's not only intermediation. It's economic intermediation. It's economic profitable intermediation. Well, and I think we have a lot of things to discuss about this sort of aggiornamento that I'm trying to emphasize. And I know that in the meetings of La Société Internationale, Professor Jorge Boucinhas, I know that the society has hosting meetings devoted to discuss and to research and to exchange ideas about what should be the strategy of this aggiornamento. But I think we have to face the agenda with more or less radicalism, but we have to face it anyway. And to conclude, I think I have about 2 minutes to conclude. If I'm not wrong, Professor Jorge Boucinhas, please correct me. I would put under a discussion the centrality of litigation, basically classification litigation, as a path to provide protections for workers in the gig economy. I mean, I understand the importance of this agenda. I totally agree with the importance of keep litigating. I understand that depending on the litigation, especially in countries like United States, that if you have independent contractor, you have no, at least at first we didn't have the possibility to unionize, even to unionize, but anyway, I think that we have to sort of try to look at from perspective the importance of classification litigation, in the sense that they are very important to provide a court recognition of the need of social and legal protection. It's important for the workers themselves to litigate in order to go for the recognition of their rights. But in terms of a systematic approach devoted to provide legal protections for workers in the gig economy, I would put under discussion to what extent it could be centrally the strategy of, clustering all the eggs in the same basket of classification litigation. Despite the importance of keep litigating and keep fighting, including before the courts, labor courts, civil ordinary courts, I mean, whatever courts we have to litigate before it. Professor Jorge Boucinhas, again, it was a pleasure, an honor to be with you all during this afternoon. I saw Jeff in a picture. I don't know if he's joining us currently. Professor Jean-Michel, it's an honor to see you, to meet you again by sort of, unfortunately, just by the minute of this screen. But anyway, and my dear friend and Professor Lee Stippet, if you're still in the room with us, really nice to see you again, to see you in this room where I've been some years ago. And well, with all this friendship, partnership, I stop here, Professor Jorge Boucinhas, and give you back the floor to do whatever you want, even to put us outside the screen. So go outside.
Thank you very much, Professor Freitas. It was great to hear you again. Since we have our president here with us, I'll ask him if he wants to propose any questions. We still have a few minutes to end this panel. Professor Jean-Michel? I think you're muted.
I'm muted, Professor Jean-Michel, please.
Okay, then so I observe that the problems are really the same in all parts of the world I know. The interesting question is that our way to try to settle it varies from one country or from one continent to the other. But it's another proof that we need to discuss to try to get new ideas. My view, from the ILO point of view, is that what is the most efficient? And I am referring to this kind of precarious workers, including in countries like India, South Africa, very, very poor countries too, is to help them to help themselves. That means that to try to strengthen their capacity to discuss with their clients or their enterprises. And it's the role of the state, in my view, in that case, to structure their capacity to discuss in such a way that they're in a position to do that. Not only to recognize those associations in one way or another, could be very informal, by a discussion on TV, like I did once, but also to help them, to train them to discuss and to negotiate.
So, Professor Jorge.
Okay, I have a quick question, and to both of you, Professor Freitas and Professor Liz Tippett, but it's a curiosity. We are about to, the ILO, it's about to discuss the regulation of work in digital platforms, and I wanted just to hear from you about your expectations. Do you think we can expect and wait for general regulation? Or what do you expect from this 2025 meeting? And well, it will be only the first round, of course. But I just want to, I really don't know what to expect myself. So I want to hear from you. What do you expect in this meeting? Oh, Professor Jeff Vogt also raised the hand. Professor Vogt, if you want to share your opinions with us.
Jeff probably has a good expectations. As I turned out to be 60, I I lowered my expectations about the ILO meetings. I have good faith, but expectations.
I will cede my time to Professor Vogt.
No, no, please go ahead. I just wanted to put myself in the queue. So anybody who wants to. Okay. No, I'm going to be on, with the workers group in the negotiations coming up in a couple of months. So just wanted to, flag some of the issues that are obviously going to come up. I think it is going to be a very difficult negotiation for a variety of reasons. If anyone has had a chance to look through the ILO's Yellow Report, which is the kind of synthesis of the responses to the questionnaire, you can see that the employers group on almost every question answered in exactly the opposite way than the workers in many governments. So there's going to be difficulty reaching consensus on many key points. And then with some key governments having changed administration in the meantime since this was put on the agenda, including the US, I think we can see some difficulty as well. One of the key issues is going to be the question as to whether we have a convention or not, or a non-binding recommendation. Questions of scope are also going to be big. The workers group has been pushing, obviously, to have this apply to all workers on digital labor platforms, regardless of how the relationship of employment is characterized, whether they are employees, dependent contractors, independent contractors. We believe that, and regardless of whether they're kind of on in situ workers, like doing ride hailing or delivery, or they're doing micro tasks on a computer, that this should have a broad scope. But I think we've seen from the questionnaire that a number of governments and employers are reluctant to extend some or all rights to self-employed workers. So we'll have that as a major fight over who deserves labor protections. So those are going to be some of the key ones from the outset. And then as we get into more of the debates around the nature of algorithmic management and how that's regulated, protection of data, surveillance, privacy related issues, those are certain to be contentious issues as well. So just a preview, I think, of year one, and many more issues will be raised over the course of the 2-year negotiations. So.
Thank you very much, Professor Jeff Volt. I will profit from this opportunity also to ask Professor Freitas to publicize his new book, the one from the seminar about gig economy, in our next circular letter. And we can, to keep our compromise with punctuality, immediately start our fourth panel. It's about collective protection of labor rights. And the first speaker is Stanley Gasek, a North American labor law that has been senior advisor for global strategies at the UFCW, United Food and Commercial Workers International Union, with 1.2 million members in the United States and Canada. Since September 2016, he was deputy and interim director of the ILO mission in Brazil from 2011 to 2016. He has been a member of the District of Columbia Bar Association since 1979. He received his Juris Doctor from Harvard Law School in 1978 and his Bachelor of Arts degree in Social Studies from Harvard College in 1974. He was a visiting instructor in the Sociology Department of Harvard University in 2008. He is the author of Sistemas de Relações de Trabalho, Exame dos Modelos Brasil e Estados Unidos, a thorough comparative analysis of the Brazilian and US labor law systems, and published by Editora LTR in 1994. This book was updated and republished by Editora LTR in 2015 in co-authorship with Professor Ana Virginia Moreira Gomes of the University of Fortaleza Law School and the current director of the ILO for Latin America and the Caribbean region. Professor Gasek also received the Ordem de Mérito from the Brazilian Tribunal Superior do Trabalho, the Brazilian highest labor court, in 2016. Professor Stanley, thank you very much for your participation. It's a great honor to have you here with us.
Muito obrigado, Professor Boucinhas. Good afternoon, boa tarde, todos a todas. I will revert to English very soon, mas agradeço profundamente o convite do professor Jorge Boucinhas Filho e do Dr. Jean-Michel Servais para participar nesta conferência virtual. Também honra de compartilhar este painel com o professor e juiz Enoque Ribeiro dos Santos. I was informed by Professor Boucinhas that this webinar would be conducted in English rather than Portuguese, and speaking English for the remainder of my time certainly is easier for me, although as Portuguese has become a second language given my long-standing ties to Brazil. There's certain advantages with my reverting to my first language. For example, you're not going to have to listen further to my sotaque puxado do gringo for the remaining 30 minutes. However, if it's easier to conduct the debate and discussion in Portuguese after my intervention, I will certainly be happy to do so. And any good lawyer will present his or her disclaimers or ressalvas before proceeding with any argument and presentation. I'm no exception. First, as I'd made clear to Professor Boucinhas prior to this webinar, I'm not an expert on American class actions, although I was involved in the preparation of a class action litigation against a major U.S. food retail company based on Title VII of the Civil Rights Act of 1964, while I was working as Assistant General Counsel for my union, the UFCW, 40 years ago. As I also made clear to Professor Boucinhas, my real expertise and interest has been in the study of comparative trade union structure, trade union law and labor relations law of Brazil, United States. I've published and spoken on this subject quite extensively over the last 40 years. For that reason, I would like to focus on certain aspects of that topic, even though previous speakers today have addressed the subject, but I hope that my comments will further supplement and build on the interventions made by the previous speakers. I'll quickly reference the issue of class actions in my brief review of the Pro-Organizing Act, also known as the PRO Act, which was ratified by the United States House of Representatives in 2021, but failed to be approved by the United States Senate. Second, warning, aviso previo, I'm not using any PPT or PowerPoint this afternoon. It would just be me talking, which may be a bit tedious. Ou seja, pouco tedioso or chato. Third warning, it will be mission impossible to cover every aspect of U.S. labor and trade union law in less than 30 minutes, given its complexity and dispersion, and in sharp contrast with what is a far more centralized regime in Brazil. My focus is going to be primarily on the National Labor Relations Act, the NLRA, and its interpretation, application, and enforcement, which covers a great part of the private sector in the United States. In other words, I'm not going to be going in detail concerning other labor relations and employment legal regimes in the United States, such as the labor relations laws for federal and state employees or the transport workers covered by the Railway Labor Act. Fourth disclaimer is warning. My presentation today is hardly value-free and definitely has a pro-union and pro-worker bias. But before proceeding with any comparative analysis concerning the labor relations law of Brazil and the United States, I think it's important to question the value of this exercise, notwithstanding the unmistakable academic value of the undertaking. And I pose this question given how fundamentally different the two systems are in a myriad of aspects. Given the system of civil law emanating from the Romano-Germanic tradition of Brazil versus a regime of case law and common law with a very strong dependence on stare decisis, which is the United States reality. Second great difference is you have a very unified and consolidated labor law system contained with the Consolidação das Leis do Trabalho, the CLT, and the Federal Constitution of 1988 in Brazil, versus a highly dispersed labor law system of the United States at both the federal and state levels, with separate legislative regimes for occupational safety and health, minimum wage, hours and basic terms and conditions of employment, labor relations for federal employees, labor relations for state, county, municipal employees, with a distinct regime for each of the 50 states in the District of Columbia, and separate legislation at both the federal and the state levels regarding discrimination in employment and profession, and, as I had mentioned earlier, labor relations legislation that's separate for railway and air transport workers. Nevertheless, the National Labor Relations Act, also known as the Wagner Act, because it was Senator Robert Wagner of New York who was the chief sponsor of the legislation, passed by the U.S. Congress in 1935, is highly representative of the legal regime governing union structure and collective bargaining in the United States, with the jurisdiction over a great part of the private sector workers, with some notable and unjust exceptions, I might add, including, for example, domestic workers, agricultural workers, and those workers classified or misclassified as independent contractors. In general, there are a lot more explicit guarantees and protections in the Brazilian constitutional and infraconstitutional system than in the United States, although there has been a radical and neoliberal shift in Brazil as of 2017 with a legislative reform of the CLT, giving a new primacy to the negotiated over the legislated, which is a concept, quite frankly, pretty alien to the U.S. legal regime. There's also a great difference between the two systems in relation to the role of the state in collective bargaining. In the United States, neither the National Labor Relations Board, an administrative agency established by the NLRA, with 5 members appointed by the president, subject to approval in the Senate with the power to issue decisions concerning representation issues and unlawful unfair labor practices, as well as the power to issue rules, which would be considered similar to portarias in Brazil, but neither the NLRB nor the courts determine the substantive outcome of the collective bargaining process. The only legal guarantee under the National Labor Relations Act is that both parties negotiate in good faith over mandatory subjects of bargaining, namely wages, hours, and terms and conditions of employment. There is nothing equivalent to a poder normativo in the United States. This point was made very clear by the United States Supreme Court in its decision of H.K. Porter versus National Labor Relations Board in 1970. In general, the Brazilian regime is still identified with the corporatist model of labor relations and the American with the contractualist. Notwithstanding these great differences between the Brazilian and the American systems, comparative analysis is important for the unionists, labor lawyers, jurists, and law students of both countries for the following reasons. First, both economies are highly significant for each other, and with Brazil being among the 10 largest economies of the world. And even with different periods of modern industrialization, Brazil and the United States share a common 20th century legacy of trade union militancy and struggle, draconian repression of the state by the state and employers, a common and contemporary institutional incorporation, legitimation and containment of both labor movements with the New Deal and the Wagner Act of Franklin Delano Roosevelt, and also during the Estado Novo period in the CLT of Getúlio Vargas. Franklin Delano Roosevelt was in Rio de Janeiro in November of 1936. Getúlio Vargas offered him a banquet, and actually during this banquet, the toast of Roosevelt was, "I want to congratulate President Vargas for having adopted the New Deal for Brazil." Not necessarily an accurate salutation, but interesting, showing the interesting parallels in terms of labor incorporation in both countries. Even though China replaced the United States as Brazil's principal trading partner well over 2 decades ago, trade relations between the two countries continue to be significant, notwithstanding the current global trade war having been unilaterally declared by Donald Trump. And the U.S. continues to be the leader or a leader in foreign direct investment in Brazil. And that's the case even with Ford having closed a fair number of its Brazilian operations several years ago. But USA multinationals such as General Motors and Cargill continue among the 50 largest enterprises operating in Brazil. Brazilian multinational enterprises have increased their investments in operations in North America substantially over the last few decades. JBS has become the largest producer of animal protein in the world, and it's the largest employer of meat packing workers, represented by my union, the UFCW. There are hundreds of thousands, if not over 1 million, Brazilians living in the United States. Many of them are working in both the formal and the informal sectors of the American economy. Query about their status given the draconian immigration and deportation policies being announced by the current Trump administration. And there was a mutual recognition on the part of the governments of both countries regarding the importance of cooperation in the labor field. In May of 2012, then Brazilian Labor Minister Brazila Neto and then U.S. Labor Secretary Hilda Solis signed Memorandum of Understanding on Labor Cooperation, Brazil-United States, which, among other things, made the exchange of best practices in social dialogue and collective bargaining a priority. This memorandum was renewed immediately following the summit meeting between Presidents Dilma Rousseff and Barack Obama in Washington, D.C. in June of 2015. And then there was, in September of 2023, the launching of the President Biden, President Lula Partnership for Global Labor Rights, also known more generally as the Partnership for Worker Rights, launched in New York around the UN General Assembly. And there was also further development and specificity developed with the Memorandum of Understanding on Labor Cooperation between both countries. And I might point out, very on a personal note, that there was a Brasilia trade union program to look at the best and sort of the worst practices of Brazilian of American labor relations for Brazilian unionists, with also a focus on contrast to the Brazilian system, with a support of the United States Department of Labor from a grant going through the Solidarity Center of the AFL-CIO, which financed a delegation of 13 Brazilian unionists, which came to the United States for this special course, which I was proudly had a role in helping to design and to teach in, was conducted at the Washington, D.C. campus of Florida International University in the first half of January. Now, we don't really know about the future of many of these initiatives, given that the U.S. federal agencies responsible for the implementation of these cooperation agreements have been, to put it very bluntly, gutted by the current administration, including ILAB, the Bureau of International Labor Affairs at the U.S. Department of Labor. And I think there's also an urgent need for an authentic understanding of both systems of what I like to call the Bolsonaro effect. President Bolsonaro had characterized the U.S. regime, often incorrectly, as a laudable example of highly deregulated labor relations with few worker protection. Current administration in the United States may be trying to push us in that direction. We're not quite there yet. While he was president, Bolsonaro said that Brazil should get rid of its specialized system of labor courts and labor justice, since the United States did not have anything equivalent. Although there were certainly certain constitutional barriers to his attempting to do such a thing. Paraphrasing his remarks during the presidential campaign of 2018, you can have employment or you can have rights, but you can't have both. But as Rio de Janeiro labor justice, João Hinda Leal Fernandes of the TRT of Rio de Janeiro has noted, the United States really is not a paradise of total labor deregulation, notwithstanding mischaracterizations of the American reality made by former President Bolsonaro and others in Brazil. Current U.S. labor law is totally inadequate in protecting against fatal anti-union practices. I'm going to explain a little bit briefly. However, consider for a moment the U.S. Fair Labor Standards Act, the FLSA, ratified by the U.S. Congress in 1938, still in effect. The FLSA requires the employer to pay a minimum premium of 150% for any work performed over 40 hours during a given work week, and without any possibility of a banco de horas as permitted by Brazilian law. In other words, an employer is required to pay the 150% premium for any work over 40 hours during the work week, even if the employee in question works less than 40 hours during subsequent work weeks. There's also the superiority of labor protections in several states in the United States Union, when it comes to minimum wage, occupational safety and health, even just cause terminations, and job misclassifications by misclassifying workers as independent contractors, as well as coverage for agricultural and domestic workers who are excluded from the National Labor Relations Act. However, it's important to mention the preemption doctrine, which is still the law in the United States regarding anything arguably protected or arguably prohibited under the jurisdiction of the National Labor Relations Act. That was established by the Supreme Court in the Garment decision of 1959. In other words, if individual states really try to really go into great detail to develop their own legislation regarding collective bargaining and union determination as defined by the National Labor Relations Act, there would be this preemption. Unlike Brazil, the United States does not have a system of unions, federations, and confederations for employers, nor a corresponding universal system of trade union monopoly for all workers based on professional category and economic activity. In the private sector, governed in great part by the NLRA, the labor relations system is not based on the principles of professional category per territorial base not inferior to a municipality in order to define the collectivity of the workers to be represented by a union. The governing legal definition is, quote, the appropriate bargaining unit, a highly variable concept in practice, often determined on a case-by-case basis, and which could consist of an employer's single enterprise or the specific sectors and units of that enterprise, such as a single supermarket in an employer's regional chain of supermarkets, for example. The guiding legal principle is the common community of interest of the workers in question. Nevertheless, there is a kind of relative unicidade, insofar as only one union becomes the exclusive bargaining representative for the workers of a given bargaining unit, if that union succeeds in obtaining 50% plus one of the workers authorizing it for collective bargaining purposes. Such authorization is generally expressed through a worker's voluntary signature of a union authorization card. Now, this legal system of individual bargaining units contributes to a regime which is highly pulverized and decentralized. This reality facilitates the employer's power to effectively repress a union organizing or collective bargaining effort at the micro level, not to mention delaying tactics which hamper or fatally preclude successful unionization. As a matter of fact, it was really the Second World War which helped consolidate individual bargaining units on an industrial national basis, leading to national collective agreements with single employers. And that's because the National War Labor Board, convened by President Roosevelt to guarantee maximum war production through stable labor relations, directed employers to voluntarily recognize industrial unions on a national basis, principally from the CIO, the Congress of Industrial Organizations. In exchange, the unions were expected to agree to suspend strikes, industrial action during the war, with collective bargaining disputes ultimately resolved through collective interest arbitration. An American labor historian, Nelson Lichtenstein, convincingly explains this grand bargain social pact in his book, Labor's War at Home, published in 1982. However, upon the conclusion of the Second World War, this de facto social pact began to unravel, and especially with the growth of deregulation and globalization in the 1970s, giving employers more leverage to pursue union-free agendas, as they are called in the United States. Nevertheless, the apogee of unionization in the United States at nearly 40% after the Second World War, as well as national collective bargaining structures, which are currently few and far between, provide historical evidence that consolidated union power is possible, even with a highly pulverized system of individual bargaining units, provided there is no concerted employer resistance and employer acceptance of these consolidated bargaining structures. American unions do not have an effective legal right of access to employees at their workplaces in order to convince them of the merits of signing a union authorization card. That's because the U.S. constitutional and infra-constitutional system has conferred legal primacy to rights of private property, namely the employer's premises, over freedom of association rights, the rights of the workers to organize a union. And after the U.S. Supreme Court's decision of Lieberwitz versus National Labor Relations Board in 1992, a case involving my union directly, the union is compelled to prove that it really exhausted nearly all other reasonable means of communication with the workers before its organizers will be given access to company premises. Even if the union succeeds in obtaining 50% plus one majority authorization from workers in a given bargaining unit, overcoming the difficult obstacle of obtaining access to the employees, there is absolutely no guarantee of unionization. And quite to the contrary, the employer may voluntarily recognize the union at that point, but is under no legal obligation to do so, given the Supreme Court's decision in National Labor Relations Board versus Linden Lumber in 1974. Also, the Gissel decision of the Supreme Court in 1969 supported that doctrine. The employer can legally refuse such voluntary recognition request, forcing the union to petition for a representation election to be conducted by the National Labor Relations Board. That doctrine was altered or amended somewhat by the Biden National Labor Relations Board and with the efforts of the former National Labor Relations Board General Counsel Jennifer Abruzzo, as I'm going to explain very briefly later. So the lapse of time between the delivery of a petition for representation election conducted by the National Labor Relations Board and the election itself, giving the employer a full opportunity to pressure employees against unionizing. One effective method has been the convoking of obligatory captive audience meetings for all the relevant employees on company premises. There was a reversal of that doctrine by the Biden National Labor Relations Board in November of last year, although query what the final outcome is going to be, as I'm going to mention at the conclusion of my comments. Moreover, many employers illegally fire their workers for pro-union sentiments and pro-union organizing activity. That's because overall the penalties and the remedies are weak, namely reinstatement of the employee with back pay. For many employers, the price of breaking the law is cheap in terms of the ultimate benefit, fatally precluding unionization of employees. Some of this was altered with the Biden NLRB, but I will get to this a little bit later. Even if the union succeeds in winning the representational election, there's no guarantee a collective bargaining agreement. That's because in nearly 40% of the cases of newly certified unions, a collective agreement is not achieved due to surface or bad faith bargaining on the part of the employer. Since the union is certified only for a year, it can run the risk of being subsequently decertified if it fails to negotiate a collective agreement. So given this legal reality in the United States, it's no wonder why union density is at one of its lowest points in the Second World War, 9.9% by the end of 2024. If you aggregate the 32.2% density rate for workers in the public sector, where there have been more guarantees of employment stability, and with the 5.9% rate for the private sector. However, the current administration has declared total war on unionism in the federal sector with an executive order to end collective bargaining, which is arguably illegal, if not unconstitutional. There were important and game-changing decisions of the Biden National Labor Relations Board. The Thrive Incorporated decision December of 2022, in which the board clarified its make-whole remedy to expressly ensure that workers who are the victims of labor law violations, for example, these firings in retaliation for pro-union activity, are compensated not only in terms of reinstatement and back pay, but for all direct or foreseeable pecuniary harm. And such direct or foreseeable harm could include out-of-pocket medical expenses and credit card debt, for example. There was the CIMEX decision of the National Labor Relations Board in August of 2023, which basically said that when an employer is presented with a request for union recognition from his employees, and they would have available the proof of majority authorization of the union, generally by means of authorization cards, the employer would have the obligation to recognize the union upon such a request, even if the employees have not filed a representation election petition, unless the employer files his own petition, questioning such authorized representation, which is known as an RM petition in the NLRB system, within 2 weeks of the worker's request for union recognition. If the employer did not do so, then the employer would face a bargaining order to collectively bargain from the National Labor Relations Board. And if the employer were to file an RM petition, but also committed unfair labor practices during the course of the ensuing representation election process, the employer would then face a bargaining order from the board. It's basically what this decision said. And then there was the Amazon decision of the National Labor Relations Board in November of 2024, reversing the earlier Babcock and Wilcox doctrine of the NLRB, established in 1948, giving employers the right to convoke compulsory anti-union captive audience meetings of employees, according to the employer free speech provisions of the National Labor Relations Act, considering, for example, Section 8C. The National Labor Relations Board found that this practice fatally violated the Section 7 freedom of association rights of workers covered by the Act. However, all of these decisions, which I just mentioned, are currently subject to appeal in the federal courts. They could also be reversed by a future Trump majority in the National Labor Relations Board. In fact, unless there is a real reform of the NLRA itself, such pro-union decisions can be reversed, and pro-worker decisions can be reversed in future administrations, including the current one, and will continue to be challenged in the federal judiciary. The Protecting the Right to Organize of the PRO Act is a legislative proposal which would make those necessary and durable changes in the law. It was ratified by the U.S. House of Representatives in 2021. It was left pending in the U.S. Senate. Prospects of passing it again at this juncture are very low for what should be the obvious reasons, given the composition in the U.S. Congress now and in the White House. But in relation to earlier progressive efforts to reform U.S. labor law, the PRO Act really is revolutionary. It would, among other things, abolish provision in U.S. labor law dating back to 1947, the Taft-Hartley Section 14B, which enables states to pass so-called right-to-work laws, which prohibit the negotiation of union security clauses and collective agreements which would require that non-members as well as voluntary members pay their fair share of collective bargaining representation costs. And this anti-union provision of the law has made it far more difficult to maintain unionization in the so-called right-to-work states, because a new employee could be easily convinced not to join the union and pay voluntary dues. And such anti-union persuasions of new employees can lead to a decertification of the union, because the union ultimately would lose, in effect, its majority authorization. Currently, 26 of the 50 states of the United States have such legislation in effect. In addition, the PRO Act would, among other things, abolish many of the prohibitions on secondary boycott action by unions. It would create real penalties for employers' anti-union behavior. It would allow for the certification of unions by means of verifying authorization cards if the employer engaged in illegal anti-union behavior prior to and during a representation election. It would provide for the opportunity of interest arbitration to guarantee that a newly certified union could obtain a collective bargaining agreement. It would ban the employer's use of permanent replacements during an economic strike, for example, to obtain a new collective agreement or renew an existing agreement. It would fine the employer practice of requiring newly employed workers to waive their rights to class action litigation against their employer as a condition of employment, to be in violation of the National Labor Relations Act, basically contrary to the principle established in the Epic Systems decision of the Supreme Court in 2018. And it would give individual workers the right to private action for violations of the National Labor Relations Act in federal district court if the board did not act on their unfair labor practice charges within 6 months or dismiss their charges. Now, this would be unbelievable in terms of advancing trade union and trade union worker rights. The chances of this ever passing, or some of it passing, obviously will depend on the future political conjuncture in the United States, and certainly not anything conceivable prior to the midterm congressional elections in 2026. But there's also the more fundamental question of the future of the National Labor Relations Board and the National Labor Relations Act itself. With constitutional challenges being filed in federal courts, including by counsel to SpaceX, Elon Musk's company, and counsel to other employers, including Starbucks and the retailer Trader Joe's, there is a question of the future, and there is the question of the legal rights of National Labor Relations Board members to complete their terms without the direct interference of the president. President Donald Trump made the decision to fire Gwen Wilcox, the first African-American female member of the National Labor Relations Board, appointed by President Biden prior to her termination of her 5-year term, arguably in violation of the NLRA and its regulations. It's left the NLRB without the quorum of 3 members, and that was cited by employers to effectively invalidate hearings at the regional level of the National Labor Relations Board, based on the argument that, well, there's no functioning National Labor Relations Board at the top, so we will not have our due process to seek review before a full National Labor Relations Board. Now, this firing of the member who gave a quorum to the board was found to be illegal by federal district court in Washington, D.C., was ultimately sustained by what was really an en banc decision of the Federal Circuit Court for Washington, D.C. at the beginning of this week. The U.S. Solicitor General of the Trump administration has now petitioned the U.S. Supreme Court for review to effectively reverse a long-established Supreme Court doctrine from 1935, preserving the integrity of members on administrative agencies, known as the Humphreys Executor Doctrine. Now, given the very strange and nefarious convergence of the Brazilian and U.S. legal regimes in terms of custódios and chacao, or trade union financing, I have argued in prior lectures, interventions, that there is a need for solidarity and exchange of best practices between both labor movements as never before. And I'm basically referring to what had been the overturning of the Contribuição Sindical by the 2017 CLT reform, constitutionality of which was sustained by the STF in Brazil in 2018. But there had been accumulated jurisprudence, including, for example, Presidente Normativo 119 of the Supreme Labor Court, the TST, finding that assistant contributions and taxas negociais would also be violative of freedom of association rights as defined by the Brazilian Constitution. There were certain hopes with the tripartite Grupo Trabalho in Brazil in 2023 to look at the future of labor relations, including the trade union centrals wanting consensus on a taxa negocial proposal, as well as the consensus on the prevalence of the principle of the most favorable provision for the workers in the face of the inversion of acordos and convenções in terms of judicial prevalence, as well as the whole principle of the negotiator over the legislated. It appears that the trade union financing issue in Brazil is somewhat mitigated by the STF's decision and Minister Barroso's opinion in 2023, which sustained the constitutionality of taxas negociais and assistance contributions. But I understand there are still many outstanding issues, including what constitutes the expression of the right of opposition on the part of the individual worker, as well as what really would be the system of financing at the federative and the confederative levels. So to conclude, the labor movements in both countries, I think, must effectively mobilize and develop public support for their own proposals and positions. Given the challenge of the legislatures in Brazil and the United States, as well as the chief executive of the United States, who is challenging separation of powers and rule of law, I would say. I don't think it's overly subjective to say so, as well as the entire constitutional order in relation to labor law. But I'm reminded of the words of A. Philip Randolph, a great trade unionist and civil rights leader, who said once that justice is never given, it is exacted. And indeed, the labor movements in both countries probably should bear this in mind for the future when it comes to labor relations law. Thanks very much for your attention. Muito obrigado pela atenção. I apologize for a very prolonged exposition, but I hope that even though I was not speaking to my originally assigned topic, I hope that I was able to maybe illuminate and to contribute and supplement interventions that were made earlier during this webinar. Thank you very much. Grande honra participar.
Thank you very much, Professor Stanley Gasek. It was really great. I think I'll analyze and reflect about all your statements for a few days now. Thank you very much. It made me think a lot. And without any delay, I invite Professor Enoque Ribeiro dos Santos to join the stage. Professor Enoque Ribeiro dos Santos holds a law degree from the University of Ribeirão Preto and an economics degree from the University of São Paulo. He obtained a master's degree in law from São Paulo State University, UNESP, in 1997, a PhD in law in 2003, and a postdoctoral qualification, we call in Portuguese livre docência, in 2011 from the University of São Paulo Law School. He is currently a magistrate with the Judicial School of the Regional Labor Court of the First Region, a visiting professor at the Autonomous University of Lisbon, Portugal, and a senior visiting professor at the Faculty of Law of Marseille, University of France, in France. He also teaches in MBA postgraduate programs at Fundação Getúlio Vargas, IBMEC, Faculdade Toledo, and Univel de Cascavel, Paraná. He serves as a federal law appellate judge at the Regional Labor Court of the First Region and is an associate professor at the University of São Paulo Law School. Professor Enoque, thank you very much for your participation. It's an honor to receive you here.
I thank you, Professor Jorge Boucinhas. I would like to greet you and also to greet Professor Stanley Gasek. It's a pleasure to be here and to present this lecture on a topic of increasing relevance in the global legal landscape, and particularly in the field of labor law, collective protection of labor rights, specificities of American class action and Brazilian public civil actions. Although both legal tools share the fundamental objective of protecting collective and diffuse rights, their historical origins, procedural prerequisites, operational mechanisms, and practical impacts present significant nuances that deserve in-depth analysis, especially in the context of labor relations. In this presentation, we will explore the specificities of each institute, seek to identify points of convergence, and mainly the divergences that shape their application and effectiveness in the protection of workers' rights. The complexity of labor relations, marked by the asymmetry of power between employers and employees, often generate disputes and transcend the individual interest. Violation of labor rights, such as non-compliance with health and safety regulations, the non-payment of overtime to a professional category, or discriminatory practices affect a significant number of workers, making collective redress an essential instrument for the effective realization of social justice and the optimization of the conflict resolution. In this context, both class action in the United States and the public civil action in Brazil emerge as procedural mechanisms designed to aggregate individual claims with a common factual and legal nucleus, conferring greater efficiency and scope to the protection of rights. Class action have a long tradition in the United States legal system, which roots in English equity law and consolidation through Rule 23 of the Federal Rules of Civil Procedure. Their central philosophy lies in the idea that it's more efficient and fair to jointly litigate the claims of a large number of people who have suffered similar damages caused by the same conduct of the defendant. The admissibility of a class action in the United States of America is conditioned on the demonstration of certain requirements as per Rule 23, and some factors such as numerosity. For example, the class must be so numerous that the joinder of all members is impracticable. Commonality. There must be question of law or fact common to the class. Typicality. The claims or defenses of the representative parties must be typical of the claims or defenses of the class. And adequacy. The representative parties must fairly and adequately protect the interests of the class. In addition to these general requirements, Rule 23 establishes specific categories for certification relevant to labor law. Rule 23 emphasizes that the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that the final injunctive relief or corresponding declaratory relief is appropriate, respecting the class as a whole, and this provision is often used in cases of discrimination or illegal company policies. The Rule 23 also is linked to the fact that the court finds that the question of law or fact common to the members of the class predominates over any question affecting only individual members, and that a class action is superior to other available methods for fairly and efficiently adjudicating the controversy. This category is common in actions involving widespread pecuniary damages, such as large-scale wage violations. You have also some peculiarity between the system used in the United States and the system of collection actions in Brazil. Only there is a lot of difference in the opt-out and the opt-in system. In class action certified under Rule 23, class members have the right to exclude themselves opt-out from the lawsuit and will not be bound by the final decision. In contrast, in action under Rule 23, membership is compulsory for all class members. Notification of class member is a crucial aspect, especially in damage action, guaranteeing the right to participate or opt out. Settlements. In terms of settlements, you can say that settlement in class actions require judicial approval to protect the interests of all class members. And attorney fees. In terms of attorney fees for the class counsel are generally set by judge in the United States, often based on the benefits obtained for the class in that particular case. Class action have played a significant role in protecting labor rights in the United States of America, allowing for the accountability of large employers for illegal practice affecting a large number of workers. Cases involving wage discrimination, unpaid overtime, misclassification of workers as independent contractors, and violations of health and safety laws are frequently the subject of class action. The public civil action in Brazil, as a procedural instrument provided for the federal constitution and regulated by the law number 7347, with the objective of protecting strict sensu collective, diffuse, and homogeneous individual rights. In this context of labor law, the public civil action proves to be a powerful tool for the defense of the interest of professional categories or a group of workers who have suffered damage arising from the same unlawful conduct of the employers. Standing to bring public action on public civil action is granted to the Labor Public Prosecutor's Office, Code Ministério Público do Trabalho in Brazil, the Public Defender's Office, Defensoria Pública, the union, the states, the municipalities, autarchies, public foundations, mixed capital companies, public companies, and associations that concurrently have been constituted for at least 1 year and includes among their institutional purpose the defense of collective or diffuse rights and interests. The subject matter of the public civil action in labor law comprises a wide range of violations, including non-compliance with labor standards, minimum wage, working hours, vacation, etc., collective moral damages, systematic discrimination, violations of health and safety at work regulations, labor fraud, illegal outsourcing, sham cooperatives, acts of administrative improbity that cause harm to workers, etc. In Brazil, you have also the possibility of undertake a civil inquiry called inquérito civil, and frequently the ACP in Brazil is preceded by a civil inquiry conducted by the Labor Public Prosecutor's Office with the aim of collecting evidence and seeking an extrajudicial solution to the conflict. You have also the possibility to obtain grant preliminary injunctions to cease the harmful conduct or guarantee the effectiveness of a future decision. In terms of effects of the judgment, you can say that the judgment of ACP has erga omnes effect, and in relation to collective and diffuse rights, and also in the case of homogeneous individual rights, the effectiveness of the collective judgment depends on the individual adhesion of the interest parties in the liquidation and execution phase, and the destination of funds in case of a condemnation to pay compensation to collective moral damage. The amounts are destined to a specific fund for the protection of the injured rights. In terms of the crucial divergence and their impact on labor law in the United States and also in Brazil. Standard to two. The standing granted to individuals and private entities in America, class action, can facilitate access to justice for organized groups of workers. In Brazil, the centralization of standing in public bodies and associations may at times limit the initiative and agility in bringing actions. Class certification. The rigorous process of class certification in the United States of America seeks to ensure adequate representation and homogeneity of the class interest. In Brazil, the absence of a formal certification process can generate debates about the scope and representativeness of the collective protected by the ACP. In terms of adhesion mechanism, the opt-out system and damage class action in the United States can lead to a greater adhesion of class members, facilitating the full reparation of damages. In Brazil, the need for individual adhesion in the liquidation phase of the civil action involving homogeneous individual rights can hinder the effective reparation of all injured parties. The model of attorney fees in American class actions can incentivize the action of private lawyers in the defense of collective rights. In Brazil, the absence of attorney fees for the active legitimates of the civil action, mostly public bodies, can influence the dynamics of collective litigation. Both class action and civil action in Brazil face challenges in their application in the context of labor law. In the United States, debates about the scope of certification, the fairness of settlements, and the role of class council are constant. In Brazil, procedural delays, the need for greater articulation between the active legitimates and the effectiveness of the execution of collective decisions are points of attention. Despite the differences, both systems demonstrate the importance of procedural mechanisms that allow for the effective protection of labor rights on a collective scale. The comparative analysis between class action in the United States and civil and public civil action in Brazil can provide valuable insights for improving the instruments of works protection in both countries. To conclude, you can say that class action in the United States and public civil action in Brazil represent distinct approaches shaped by their respective legal system and procedural traditions for the protection of collective rights in the field of the labor law. Understanding the specificities of each institute, their advantages and limitations, is fundamental for legal professionals working in this area. While American class action stands for private initiative in bringing actions and the possibility of presumed adhesion of class members in damage cases, Brazilian civil public civil actions emphasize the role of public bodies in the defense of collective and diffuse rights, generally requiring individual adhesion for the execution of homogeneous individual rights. The exchange of experience and comparative analysis can contribute to the development of more efficient and fair mechanisms for the protection of workers' rights, and in a globalized scenario where labor violations often transcend borders and affect a large number of people. I would like to thank Mr. Boucinhas for this invitation and the opportunity to participate in this important debate. Thank you very much.
Thank you very much, Professor Enoch. It was great to hear from you again. It was an honor to be your student a few years back in time, and we finally reached to our final 50th and final panel. It's called Judicial Precedents as Mechanisms from the Construction of Labor Law in Brazilian and American Law. It is both an honor and a privilege to introduce Professor Janis Bellatti, one of the honorary presidents of our society. Professor Bellatti has had a distinguished career marked by exceptional contributions to the field of labor and social security law. She served as treasurer of the International Society for Labor and Social Security Law from 2015 to 2018, and as its president from 2018 to 2021. And her international leadership extends further. From 2009 to 2012, she was president of the International Labor and Employment Relations Association, ILERA. For 15 years, between 1995 and 2010, she was a valued member of the Committee of Experts on the application of conventions and recommendations of the International Labor Organization, a role that underscores her deep commitment to the advancement of global labor standards. Professor Bellatti is currently a professor of legal studies at the Wharton School of the University of Pennsylvania, where she specializes in international comparative labor and employment law. Her work has shaped scholarly discourse and influenced policies across borders, and we are truly fortunate to welcome her today. Professor Bellatti, thank you very much for your time and for accepting our invitation. Professor,
Okay,
okay.
let me start again. Okay. Thank you, Jorge, for that generous introduction and to the Society for organizing the webinar. I said I have a cold a bit, so my voice sounds a bit strange. When you were in the last session, it's always a question of not repeating what's been said and trying to pull together some thoughts of what people have said and give some insight. I know that when Jean-Michel Servais conceived of this webinar, he was thinking of the difference between common law and civil law. So let me give you some thoughts on that. Maybe the others can comment. About, thinking how long ago this was, about 10 years ago, I was asked by the publisher Elgar to be the editor of a volume, a research volume called, they were going to call it Labor and Human Rights. By the way, I suggested they called it Labor, Business, and Human Rights Law because I said, well, if labor has rights, someone has to respect those rights. And I was thinking that maybe we should put a focus on the obligation of employers, or let us say business, to do that, not only government. In the discussion I had, or the various conversations with the authors of the chapters, many of them would say, well, they found this difficult to think about. I mean, it was a fundamental right of workers to do such and such. And I would say to the person, it may be fundamental in your country, but it's not fundamental in my country. So where are these fundamental rights found? Generally, there were two responses. The most common was that the rights were in the Constitution. Sometimes, because these are fundamental rights, sometimes the response was that they were in an international convention. Especially like Europeans might say, well, that's in the European Convention of Human Rights, etc. Well, that I would like to discuss that for a second with regard to the United States. Constitution of the United States, the main part of it, was written in 1787. That's before the Industrial Revolution, and it's at a time when people thought people in the United States who were writing the Constitution were thinking about frankly, their social class, which was property owners, educated property owners. So in the United States, you might hear people today say, well, they didn't include slaves. Well, you're right, they didn't include slaves. They did not include women, nor did they include or thinking about men, white men who did not own property. Not in 1787. And even when now I want to go to the Bill of Rights. Many people mention the Bill of Rights. The Bill of Rights, nearly every article of it says no state may do something. I mention that because it does not apply to private actors, in particular employers. That's what I'm thinking of. So it says no state may deny freedom of association. It doesn't say anything about whether employers can. So that's our federal constitution, which has been amended, but compared to Brazil, I can assure you, very little. There's less than 35 amendments in 250 years. 240, but mainly partly because it's extremely difficult, the process of trying to amend the United States Constitution. So that in labor rights, it is rare for anyone to try to make an argument based on the United States Constitution. The next thing about international conventions, as many of you know, the United States has ratified very few ILO conventions, very few. And in fact, it's only ratified 2. I should say there's 10. So there's only ratified 2 of the 10 core conventions. It has not ratified freedom of association or the Convention 98 on collective bargaining. So that's not a source. Even when we have ratified something such as the International Convention, pardon me, the International Covenant of Civil and Political Rights, another feature of American law kicks in. Many countries, when they ratify an international convention, it immediately applies or can be applied in the country, a monist system. The United States is not. It's a dualist system, and even if we ratified a convention, Congress has to do something to make it applicable in the states. So I only mention that because this notion that there are fundamental labor rights simply, for the most part, doesn't exist. If you came to my home city of Philadelphia and you talked to practicing labor lawyers and you said, well, what are the fundamental labor rights? They would look at you blankly. Very quickly, they would start talking about statutes, which of course can be repealed or amended, etc. So I really want to strongly emphasize that the idea that we have recognized fundamental labor rights, we just haven't. And in fact, it strikes me that when in this book I was discussing with you, several countries that were covered had rewritten their constitution, sometimes for different reasons, after World War II. And most countries where a constitution had been rewritten or substantially amended did look at the Universal Declaration of Human Rights. Of course, the United States has never done that, and it's very rarely mentioned. Okay. It's not even covered. When I was in law school, nobody even covered the Universal Declaration of Human Rights. So we have to look at statutes. The previous speakers have discussed our main labor relations statute, the National Labor Relations Act, which was passed by Congress in 1935. Actually, it's not been amended that often, as they may have mentioned. 1947 and 1959. That's it. It's barely been touched since then. So we have a statute where the model is 90 years old. And then the last time we touched it was in 1960. So you could see maybe it's, when I say out of date, I don't mean totally out of date, but it hasn't been updated to reflect new patterns of working. And as mentioned, the National Labor this is more complex. In the Constitution of the United States, most of the Constitution, how can I put this? The states were forming a country. What had been colonies were forming a country, and they were deciding which powers they had would be given to the federal government. So it's called a government of limited powers or enumerated powers. So if you make an argument about what the federal government can do, you have to point to something in the Constitution. Now, the notion of what the federal government can do has been expanded, but there's still arguments about that, about what the federal government can do. But having said that, as I said, the Constitution doesn't discuss employment. So you say, well, what can the federal government do in employment? So in 1935, in a rather bold move, the new Roosevelt administration made the assertion that, well, the federal government does have the power to regulate interstate commerce, and therefore the federal government has the power to pass a statute that will regulate certain activities that often lead to an obstruction of interstate commerce. So it was limited to basically unionized, well, employees who had joined together, usually unionized, taking action in response to their demands, and often striking. That would be an obstruction of interstate commerce. My topic was supposed to be this judicial, but that is the first major judicial decision. Was the statute even constitutional? I should tell you, the decision was 5-4, 5-4. It was very close, and it's clear constitutional. But it said mainly that Congress was regulating and wanted a certain process, which would be collective bargaining, but it wasn't dictating an outcome, which would be a collective agreement. Okay, so it was somewhat limited even the initial decision was limited. The second thing I'd like to mention about the original statute, and even with the amendments, you'd be surprised how short it is, and not very long at all. Compared to when I look at the French Code de Travail, I mean, it is not long, and there is no unified equivalent to countries that have a labor code. It isn't. So the National Labor Relations Act sets up certain things. Well, but because it's so short, it left a lot of room for interpretation. And it almost had the common law view that over time, there would be case law that would develop and build a body of law. And in some ways it has, and it really has. But remember that this is a short statute, and even worse, I have to say, even worse, there was not a long, like a year's worth of discussion about this statute. I say that because we look often at congressional intent, and you can't find it. You just can't find it because I don't want to go into history as Stan did in his, but there had been a previous statute that was meant to regulate the economy, and it had one section called Section 7 that was designed to give workers rights. This other statute called the National Industrial Recovery Act in the end of May of 1935, the entire statute was declared unconstitutional. Everything. And so the people who were interested in the labor section, which was called Section 7, they raced through a statute. It was passed in 6 weeks. So there's not a lot of discussion. And the way it's written in a way that I think no labor relations scholar would write it. I have to say that. Lawyers might think of it in this way, but not labor relations people. I think Jeff Voigt was mentioning that we don't have sectorial bargaining. So a lawyer's thinking, well, if we're going to have a collective agreement, who's covered by it? Well, employees are. Okay. They didn't define who employees were. Then they say, well, they already knew employers would not want to bargain. So they said, well, they have to bargain with the people in the appropriate bargaining unit. What is an appropriate bargaining unit? Absolutely nothing on it. One of the most idiotic things, and this is my opinion clearly, you can have a union organize many different parts of the same company, and they do get a collective agreement in each part, but the expiration date of it are vary. They have no ability to put those together. None. Unless the company will agree to it. And they can't even have much of an effective strike because for the most part, you can't go on strike until the contract expires. So you see how crazy, if someone was sitting down who had lots of labor relations experience, they had 20 experienced labor lawyers in the room and thought about how is this going to work in practice, they would have written a different statute. Or if they had looked at certain European countries that already had developed labor relations, they might have written a different statute. So we left all these questions open. We still argue about what an appropriate bargaining unit is. When workers organize, one of the first, and they go to the National Labor Relations Board, the regional office, and say, we want an election. Sometimes the employer will say, that's not an appropriate unit. Then you sit there and waste time, months, many months, arguing about what's an appropriate unit. And as Jeff White, I think it was Jeff said, you lose support among the union, particularly if it's the type of workers where they turn over a lot. So think that 90 years afterwards, we're arguing about such things because it was never defined. Another, the issue of who was an employee, and Liz Teppet was mentioning this. All it says is as employees of the employer, employees of an employer. But that's a common law notion of who an employee is. And in the United States, employment is state law, not federal law. So as she mentioned, even now, you would say, California might say this is an employee, and Alabama might say they're an independent contractor. It's very, very odd. That's number one, that we don't have a unified nationwide view of who is an employee. By the way, it has, and even stranger, which wasn't mentioned, you can be an employee for purposes of the Social Security Act, but you're not an employee for the purposes of the National Labor Relations Act. That's how strange it is. That's what happens. So we have this unusual interweaving of common law with statutory law, and with no reference, almost no reference to, in a comparative law sense, with any other country or with, like I said, the ILO or anything. Now, how does this get played out? As mentioned, by the way, this has changed a lot over time. I mentioned elections. The statute did provide for elections, but it didn't say they were required. And prior to 1947, there were not many union elections. After Taft-Hartley, there were more, and because of Supreme Court decisions in the 1950s, many more. It was a conservative Supreme Court, and they seemed to take the view that if the employer had a doubt whether there was a majority, there had to be an election. So that's an example of political ideology affecting one's view of what the statute meant, and that's changed over time. So do you need an election? As you know, most countries do not have union elections. It's unusual, but we do. And all the rules involved, where the National Labor Relations Board, the 5-member board, might in a case take a view on what's required as you move towards an election. It could be changed by the courts. The way it is the National Labor Relations Board makes a decision to get enforcement. It goes into our middle level of courts, the courts of appeal. They either uphold or reverse that. And then the losing party can take it to the Supreme Court. And so you get differences over time on some of these issues. And one of the big ones recently was whether doctoral students at universities can be unionized. At American universities, doctoral students often have to do some work as part of their studies. They may be teaching some courses and they are compensated. That was a huge issue about whether they could be treated this is at private universities, not public sector, private universities, whether they could be unionized. It's flip-flopped. This is in the last 20 years. In fact, it may flip-flop again. Whether the athletes at American universities, particularly football players who, some of you may have seen that 100,000 people will turn out to see a football game between two big universities, whether they can be unionized. So in this day and age, we're still trying to decide who an employee is. And that's this issue of not having really a developed body of law, and things can be changed. And there were things that we thought were accepted, but maybe were not. And I think both Stan and Jeff mentioned this. The statute says the National Labor Relations Board has 5 members and they have 5-year terms. You might say by tradition. What happens is there's staggered terms. Every year, one of them should come up for renewal. And by tradition, the president nominates someone to be on the board and the Senate should approve it. And therefore, you should have 3 members of the board should be of the president's party and 2 of the opposite of another party. Well, President Trump isn't following that rule in 2 ways. He's just not appointing people. And then the second one is he just fired somebody, which is not permitted by the statute except for a specific cause, which doesn't even relate in this case. So it's a twofold. But it'll show that on this important point, like, should you have 5 members that are the same party as the president or not? It's not mentioned in the statute. So that case will, the circuit court just decided. That'll probably go to the Supreme Court. It affects many other federal administrative agencies, but the National Labor Relations Board will be the first one. I made so many notes and I'm trying to figure out, I don't want to get people too confused by what I am saying. In general, the biggest difference I see is that in the United States, there are many very important issues that we don't have a statute on. If workers are unionized, they probably have this right. So I will give you 2 or 3. One is, can the employer dismiss someone for no reason at all? Or should there be, as we use the word just cause, you might say fair dismissal, fair process. Nearly all union collective agreement where people are unionized, collective agreements say that an employer can discharge or dismiss only for just cause, and then there's a whole process. Somebody's dismissed, you file a grievance, it goes through the process, and then it goes to what's called arbitration. I'm going to use that word carefully because the way Americans think of arbitration is different than in other countries. Come back to that. However, that's only in the private sector. Only about 6 to 7% of employees in the private sector are unionized. So let's say over 90% of American employees do not have that protection. They are deemed employees at will. They can be dismissed, the saying is, for good reason, bad reason, or no reason at all, except for some statutory prohibitions, like you can't dismiss somebody because the person's Black, for instance. Okay, discriminatory reasons. But that's it. And that goes back to the late 1800s, and that was made by state courts. That view is very different than other common law countries. It wasn't even British law at the time. We just did it. So we don't have a right against a right of fair dismissal. We don't have that. We don't have any, except for a few states, we have no redundancy payment at all. And we don't have some countries like Britain has. Most countries talk, in fact, nearly all civil law countries talk about contracts. The contract of employment often is presumed to be of indefinite duration unless it's stated otherwise. And then there might be statutes to combat against abuse of contracts of a limited term. In the United States, people don't even think of a contract employment. We've even had, each state would decide. States next door to each other can have different rules. Imagine this one. You go to work and they hand you a a booklet, and they say, these are the rules of the workplace. And there's the rules of the workplace, and you sign it and say, fine. And then 3 years later, you get dismissed with no warning, no mention of any cause. And you say, but in the employee handbook, it said that I would have a written warning. So the issue would be, does the employer have to abide by the company's own employee handbook? You wouldn't believe this, but in New Jersey, the New Jersey State Supreme Court said, yes, it's your handbook, you have to follow it. You could have changed it, you didn't. Pennsylvania takes a different view. Pennsylvania says, oh, since the employer could change it at any time, everybody knows it's more of a public relations statement, and the employer does not have to abide by its own employee handbook. So this is the extremely complex nature of private sector employment law in the United States, with the unionized sector, and in the private sector, it's very much smaller, having much more, in my mind, security and stability of employment and fairness injected in it than in the non-unionized sector. By the way, for the public sector, every state makes its own rules, and they can vary from state to state. I'm very proud of my state. Pennsylvania is one of the few states that, for a large measure for our public sector employees, follows what the ILO says, but many don't. And in the federal sector, where the president, by executive order, can do many things, it used to be that since around President Nixon, the federal employees certainly could join unions, and they could engage in collective bargaining, but they were not allowed to strike. And then under President Reagan, he fired all the air traffic controllers when they went on strike, but they could engage in collective bargaining. And last month, President Trump said that federal employees could not engage in collective bargaining, wouldn't bargain with them. That gets us back to freedom of association. So I'd like to say that if you looked at the Constitution of the United States, it says that no state may deprive people of freedom of association. And you might argue, but isn't it a right of employees to be able to associate, join a union, engage in collective bargaining? Well, I've never seen that argument made in the United States in a federal court. I can think of exactly one Supreme Court case, and actually it was on freedom of speech, where certain employees were picketing peacefully, very peacefully, with a sign, that was saying that the employer, unfair wages, demanding more, and they were arrested, right? And they challenged this and said it was unconstitutional for the state of Alabama to convict them of a criminal offense for what they were doing. And the Supreme Court agreed. They said they had freedom of speech because there was no violence, no threatening conduct, just speech. And they said, no, they couldn't do that. That's the only case I could think of before the Supreme Court where someone, a union or whatever, tried to make a constitutional argument. In the case, you always are relying on the statute. And when you're relying on the statute, you're looking at how it's been interpreted over the years. And it really has changed since the beginning. So it's a rather negative view, but I couldn't even begin to compare it to Brazil, which has such a completely different approach to how the law is used and regulates labor relations, much more in line with, as I said, I'm thinking of France or Spain, whatever, civil law countries. And of course, having ratified many labor ILO conventions. I mean, I do know that Brazil, of course, has changes in its government. This can this can lead to changes in the Constitution, if not in statutes. That I am aware. But I'm just thinking of a lawyer, how you're looking at how you use the Constitution and then statutes to regulate labor relations is extremely different than in the United States. Well, I've talked a long time, so I think I should stop there and let the other speakers speak. Thank you.
Thank you very much, Professor James Bellacci, for your lecture. It was really, really interesting, and also for accepting our invitation. And I'll move now to my dear friend and Professor Sérgio Torres Teixeira. He will talk about precedents to constructing labor law. Sérgio Torres Teixeira has served as a judge since 1991 and is currently an appellate judge at the Regional Labor Court of the 60th Region, Pernambuco, Brazil. He is currently a full professor at the Faculty of Law of Recife and a full professor at Unicap, where he teaches in undergraduate programs, lato sensu postgraduate programs, and both master's and doctoral programs. He also serves as a professor, scientific coordinator, and director of the Higher School of Labor Magistrates. He is also a professor trainer at the National School for the Training and Improvement of Judges and the National School for Training and Improvement of Labor Judges. He holds the chair number 33 at the National Academy of Labor Law and the chair number 16 at the Pernambuco Academy of Legal Letters and the chair number 2 at the Pernambuco Academy of Labor Law. He is also a member of the Italian-Brazilian Institute of Labor Law, the Brazilian Association of Procedural Law, and the Brazilian Institute of Procedural Law. Professor Sergio, thank you very much for accepting our invitation. The stage is yours.
Okay, thank you, Professor Boucinhas. You just forgot my most valuable title, which is being your friend. Our friendship I value over any formal title I have. And let me register that it is a great honor to participate in this event, especially one having professors that I really admire, as Professor Janice, as Professor Michel. And so it's just an incredible honor and to be able to participate. And I was very fortunate to be chosen to speak about the judicial precedent system in Brazil, which is something I have been studying very closely for the last 10, 12 years, right after our civil procedural code. And so it's something that it's pretty much part of my day-to-day. And I recently published an article in the Beijing Law Review, which was entitled an introduction to the introduction of judicial precedents in Brazil. Like, it's really, really interesting for someone who doesn't know how our system works, and to see what we have here in terms of this new mechanism of forming judicial precedents and how it is impacting our labor system here in Brazil. And so it's interesting. Professor Janice mentioned, and it is true, that usually when you think about Brazil, you think, okay, Brazil is in the model of a civil law country. Okay, their legislation there comes directly from the National Congress, eventually from international treaties ratified by their parliament. But the main source of labor regulations is our legislator, which is true. That is our tradition. But we do have some interesting participations of the judiciary in the labor norm creation as fountains of labor norms. If we go back to the early 1940s, actually 1943, our main legal diploma to this date, which we call the Consolidation of Labor Laws here in Brazil, the CLT, it had in its article 902 the the provision of what we used to call prejudgments. It was in Portuguese to be pré-julgados, which was a manner in which something decided by the Superior Council of Labor at the time. That was the name of which is presently our Superior Labor Tribunal. If it decided on an interpretation of a certain norm, that interpretation would be binding for all of the lower labor courts. And that was really interesting in that way, because it was specific for the labor judicial system. But in 1946, it was declared unconstitutional by our federal Supreme Court. So that attempt to have the judiciary specifically defined interpretation of any sort of law, but specifically labor law, was not successful because of the position of our Supreme Court. And another particular way that the judiciary does present itself as a source of labor laws is through Articles 856 and 875 of our CLT, of our Consolidation of Labor Legislation, which structures how our courts can decide on collective claims which are not come with a solution through collective bargaining. And here we call the result of these judgments by our tribunals sentenças normativas, which is a way where the tribunal, where our courts actually defines certain labor norms which will be applied within the representation of the syndicates and the unions involved in that clash of proposals. But it's very limited because it's specifically gonna treat only the things that were taken to the court by those unions. And so it isn't actually creating law, it's deciding over disputes in collective situations when the parties, the union parties, simply were not able to make that decision. But besides that, besides our pré-julgados, our prejudgments, beside our sentenças normativas, or normative decisions, we have a tradition through the labor courts of creating norms through what here in Brazil, Professor Janis, we call súmulas. I've tried to translate the expression súmula. I've looked in like 5 different dictionaries, Portuguese, English law dictionaries, and I really haven't found a perfect concept of what a súmula is. I can try to translate it as a manifestation, a pronunciation of a court that forms a summary of the result of a judicial ruling that materializes an abridgment of law. That's the concept I'm going to bring to you. Okay, a súmula is like a concise text where the court tries to summarize their thinking, their decision on a certain specific case, and leave that to be an orientation for the judges of lower jurisdiction. But the curious thing about the súmulas is until recently, they were not binding. A judge did not have to follow that concise orientation that was exposed by the superior courts. And that was very interesting. Even though it was not binding, we still would think of it as a source of labor norms, because to be totally honest and quite frank, our legislator, in terms of labor regulations, is usually very tardy, very slow, and sometimes totally inert and in inertia. And so we have to depend on the courts to give guidelines of how we should treat certain situations involving labor relations, which simply are not depicted in our legislation, our federal legislation. So our súmulas have traditionally represented a way where we would find some sort of support in order to take position in cases involving disputes which simply would not attract a specific norm from our labor legislation. But then two curious things happened in the past few years. In 2015, Federal Law 13105, our Code of Civil Procedure, was introduced into our system. And even though this code treats civil procedure, it has a very big impact on our labor procedure, because our CLT, our Consolidation of Labor legislation, has only a few norms treating the procedure in labor cases. And so we are truly dependent on the Code of Civil Procedure. And so it offered a very interesting impact on the way we handle our cases, but specifically in terms of sources to create norms, labor norms, it wasn't actually embraced by the Brazilian judiciary and by lawyers in general right at the bat. It took a while for us to start thinking about these possibilities. Another interesting thing was 2 years later, Federal Law number 13467 of 2017, our labor reform, changed a series of norms within the Brazilian judiciary, specifically our labor judiciary, which ended up making the civil procedural code very attractive to us. It's interesting. One of the changes that this labor reform did within our procedural system was established on with the changing of the text of Article 8, paragraph, the second paragraph of our CLT, that through sumas we could not restrict legal rights that were provided by our legal legislation, and we could not create obligations that were not supported by law. And so it was an attempt through our legislator to restrict or control our superior labor tribunal, the main court in terms of our Brazilian labor judiciary, which had this tendency to regulate through its sumas. But now Article 8, second paragraph, impeded any sort of attempt to create new rights or to create new obligations through sumas. And another interesting thing was in Article 702, Item 1, letter F, because it established a very complex formula for creating or changing, for creating new sumas or changing older sumas. It required that to establish or amend sumas, that there would have to be, or other statements of uniform justice, it would have to be done by the vote of at least 2/3 of its members in matters that had been judged identically in a unanimous form in at least 2/3 of the panels which work within the Superior Labor Court, which there's 8 panels, so 2/3, it'd have to be at least a total of 7 working and deciding unanimously about this subject in order for us to be able to have a new summa. So these changes by the labor reform made it practically impossible for our Superior Labor Tribunal, that's the top court in our Brazilian labor judiciary, to edit new summas and treat situations which were not depicted in our labor legislation, but needed some sort of intervention by the state for us to have orientation on how to decide whenever a case did show up involving this subject. So this situation, this very interesting situation, ended up making the Brazilian labor judiciary turn to the Civil Procedural Code. Why? Because in the Civil Procedural Code, there was an attempt to create a system of judicial precedents. And in this system, depicted in Article 927, there were appointed 5 different types of judicial precedents which judges of lower jurisdiction would have to follow. And of these 5 topics or 5 items, one in particular is very interesting, which is in Article 927, Item 3, which treats or depicts decisions which are made in the incidence of jurisdictional assumption or incidence of resolution of multiple claims and decisions in incidents of multiple or repetitive appeals that are ruled over by the Supreme Court or by the superior federal court, or in our case, by our superior labor court in our system. And these sort of precedents that are depicted, that are previewed in Item 3 of Article 927, are binding. Lower jurisdiction judge would have to follow. So it became a channel, it became a path in order to have this continuing form of the judiciary and its jurisdiction become a source of norms for our labor relations. And it was very interesting because I don't know if Professor George remembers this, but in September of last year, in our international congress of the Brazilian Academy of Labor Law, I was chosen to give a speech on exactly this mechanism of creating precedents through this incident of repetitive claims. And during my lecture, which we had in the audience various justices of the Superior Labor Court, I mentioned that we had a serious problem here in Brazil, a very serious problem. And I tried to show some numbers that we had. And I showed that in 2023, we had increased our stock of cases by a considerable amount, more than 28%. The Brazilian labor judiciary got more than 4.1 million new labor cases in 2023. And so our stock of cases to rule over was over 5.4 million. And what I try to show is that the use of these mechanisms, of the incident of assumption of jurisdiction, of the incident of repetitive claims, and of the incident of repetitive appeals, we simply weren't using them. The number of regional tribunals and in regional tribunals was very small, and the numbers in the Superior Labor Court were even smaller. And if we compare our federal Supreme Court was using these mechanisms with much more accuracy. Just in terms of comparing numbers in terms of 2023, we had in our federal Supreme Court more than 1,300 of these incidents. And within our TST, or our Superior Labor Tribunal, we only had 25. Look at that comparison. Over 1.3 thousand in our federal Supreme Court and only 25 in our Superior Labor Court. I mentioned that this was a serious problem. This was a serious problem, that our Superior Labor Court was not going to this mechanism to not only resolve those cases, but to establish judicial precedents which would be binding for our judges of lower jurisdiction. I don't know if it was a coincidence. I would love to think that I did have a little bit of influence Professor Boucinhas, but I think it was a coincidence. But in February of this year, of 2025, our Superior Labor Court ruled over these 21 of these repetitive appeals cases and defined 21 new judicial precedents. The cases were ruled over in February, okay? They had to have some time to write up what the precedent, the text of the president was. They were published last month. And it's really, really interesting because as of March, we have now these judicial precedents that are binding for lower jurisdiction judges, which in terms and makes it labor norms, which rule over and give us orientation on various cases, which are really interesting, such as overtime for women in the intervals, and in terms of reparation when the titles from a dismissal aren't paid, or when we have what we call an indirect rescission, when the employer adopts a position which allows the employee to think that he is being fired indirectly, commissions for bankers, for bank employees, the dismissal for pregnant women on the job, and various other subjects are now object of these judicial precedents that are binding. And so now, in my humble opinion, I think our Superior Labor Court woken up, has understood the incredible power that they have, that our justices have, to create these norms through binding precedents, ruling over these cases involving repetitive appeals or repetitive cases in the first level, or this assumption of jurisdiction. And so we have now, through our Code of Civil Procedure, many mechanisms that serve as the formation of norms through judicial precedents. And so even though we still would be classified as a civil law country, I think we have at least one foot in the system of the common law, and we have seen our judiciary be called upon and react. And even though we are criticized many times, and they talk about judicial activism in this sense, we do this because, like I said, we see inertia or tardiness in our legislator in many situations, which need to be defined. We need to have these orientations for our judges of lower jurisdiction. And I think now that we're coming into a new era where we will see this more effective power being exercised by our Superior Labor Court with the use of the system of judicial precedents as depicted in Article 927 of our Civil Procedural Code. So that is a big novelty that we have had this past few years, specifically this year. I think is this awakening of the Superior Labor Court in terms of the power they have through this mechanism of forming judicial precedents that are binding. So that is going to be very interesting. I'm very happy with this situation and very excited to see how it's going to play out as a justice in a regional court, and seeing me and my colleagues now applying these precedents, because it will be a way to attend the demand that we have in this incredible situation involving numbers which are just sky high in terms of labor cases. Well, I think, my dear Professor Boucinhas, that was my main objective, which is to talk about this novelty. How it's going to work out and playing out, Professor Janis, you can call me in a year, maybe a year or two, and I'll tell you. I'm very excited for it. I think the judiciary, the Brazilian judiciary, has to act in this sense. It's part of our responsibility also to participate in the solution of conflicts in labor relations. And I really do think that in this sense, we are contributing to making a better society here in Brazil. Thank you, Professor Boucinhas.
Thank you very much, Professor Sergio. I totally agree with you. I think we have a foot in the common law system. I wrote this, I think, 15, 16 years ago, even before this new institute. And one of the examples I shared back then was the one of outsourcing. We had the outsourcing consequences and procedures in Brazil regulated for decades by a súmula, by a judicial provision, because we simply a law, an agreement to create a new.
I think he's having some connection problems. I'm not sure if Professor Boucinhas is having some connection problems.
Yes. You're mute, Michel.
Okay. Probably it's just something temporary.
I think Jean-Michel, why don't you conclude? You have to turn your microphone on.
Yeah. Okay.
Well, I think it's for Jorge to conclude. He was the main organizer of this seminar. What I could say, waiting for him to appear again, that's I consider that the best of this International Society for Labor Law and Social Security is to give the opportunity to compare systems and to really do work on comparative labor law. And this kind of seminar that I hope we will be able to repeat, and including with other countries, is at the core of my priorities during my presidency in the International Society. I am very grateful to every one of you, including, of course, Giannis Bellacci, who was president before me of the International Society, amongst other questions, to participate in it and to try to come back to the I would say the main points in comparing and in grouping ourselves and discussing is to compare our law and to try to draw the best of each one and to construct new rules based on experiences. I see that Jorge is back, so if he hears us, I will give him the floor to conclude.
No, actually, Mr. President, I would ask you to do that, to give us the closure of this wonderful journey. I just want to say that was extremely enriching experience for me, and I hope to everybody that was somehow involved with this wonderful event. But please, the word is yours to conclude.
No, I was just doing it without you. So I will not repeat. Maybe we could do that apart. But thank you to everyone. And I hope that will also mobilize a number of colleagues from the United States to join us for other activities. And we have a Congress in 2.5 years' time now in Mexico. And the focus will be again on comparing legislation and labor law on various issues, the issue we mentioned on the site. And I invite you to look at the site because it's too late now to do it. So thank you again to every one of you. I enjoyed this seminar and your lectures. and I hope we will do it again. Thanks also to Jorge, because he is the organizer of this. Okay, so bye-bye to everyone.
Bye-bye.
And have a good, for me, it's a good night. It's over midnight. Bye-bye.
Bye.